2019, June 27th of 2019, July 6th of 2019, July 8th of 2019, and as well as August the 12th, 2019, September the 4th, 2019, and all the way up through January 30th of 2020. And that was in violation of that protective order. Mr. Holmes' criminal history includes 7 felony convictions. Starting in 2006, there were convictions for possession of cocaine, possession of methamphetamine with intent to distribute, theft by receiving, another possession of cocaine, and 3 other convictions for possession of cocaine with intent to in this matter, we would ask that Mr. Holmes be sentenced for the aggravated stalking charge, 10 years, served 1 year, the balance on probation, and to have no contact with his ex-girlfriend, Princess Davis, Princess, Princess Davis, Davis, and her current boyfriend or then boyfriend at the who is Kenetita Miller, Keneteeta Miller.
Can you spell the other name?
Hold on. Can the deputy lower it down back there, please? At the jail?
Ma'am?
Can you lower it down, please?
It's something I can't hear.
Thank you.
No. Ma'am? Yes, ma'am.
Can you tone it down, please? We couldn't hear her, please.
Yes, ma'am. That was another officer. I got it.
Thank you. Go ahead, Mayor.
We can pick up with the spelling of the second name.
Okay. K-E-N as in Nancy, E-T as in Tom, E-E-T as in Tom, A, and then Miller, standard spelling, M-I-L-L-E-R.
Thank you.
That's all from the state, Judge.
Okay. Counsel?
Yes, Judge, thank you. We ask that you accept this plea as negotiated. As Ms. Chan indicated, there was a run-in, and we aren't going to go too much into the facts of that, but it is the other case on the calendar that's being null-prossed, and as a result of that, my client was shot 11 times. He's had a lot of health issues following this. He's had part of his intestines removed, and he's been back and forth to Grady. But I want the court to know that my client takes full responsibilities for these contacts with Princess Smith. What happened in this case is after he was arrested.
Princess Davis.
Princess Davis.
Yes, Princess Davis. Thank you. Mr. Holmes was taken from the jail over to the courthouse where he signed this protective order. And I have now more fully explained to him what those conditions are and all of the details and restrictions of that. At the time, he didn't have a lawyer. He didn't really fully understand the indirect contact stuff of that nature. And I also want the court to know that of these contacts, none of them were threatening. Some of them were him reaching out to her, asking how she was doing, how her kids were. The week prior to this run-in, he had actually taken her kids out to eat. So they had been together for a while. He did care about the kids. And so I just want the court to understand that he wasn't trying to harass or threaten her. I have since explained to him that just checking on the kids, that is still a felony, and he can't do that. And so I don't think that we're going to have any problems moving forward with this. I also understand that he does have prior felony convictions from 2005 to 2009. I want to highlight that those are over a decade old, and those are predominantly drug charges. He is a different person now. After that last conviction, he has really worked hard to turn his life around. He is a high school graduate, and he was working at the DeKalb County Sanitation Department for 8 years. He had also gotten a job at B-Dry Waterproofing Company, where he did worked on water systems. And so he was very focused on trying to be there for his son, who is 14 years old, work and be there for his family. Most of his family is here in Atlanta. His mother does live in Virginia, but his mother and father have been very involved and supportive of him throughout this entire process. So I believe he understands why he's being charged with this case. There won't be any contacts in the future, and we appreciate the state dismissing the aggravated assault case based on a lot of the factual discrepancies. So we just ask that Your Honor accept this plea as negotiated, and we appreciate the court's time.
All right, Mr. Holmes, how old are you?
Mr. Holmes, you're on mute. Can you ask the deputy to unmute you?
Excuse me, sir, can you unmute?
Okay, Mr. Holmes, how old are you?
I'm 33 years old, sir.
And do you have any children?
Yes, sir, I have one son.
Could you step a little bit to your right to get more in the picture? There you go. And how old's your son?
My son is 15 years old, Judge.
How long did you and Miss Davis Miss Davis date each other?
I say 8 to 10 years, Judge.
But you have no children with her, right?
No, sir.
Do you understand that you can't have any further contact with Miss Davis?
Yes, sir.
And you can't have any contact with the children. You just need to get that out of your system.
Yes, sir, I understand that, Judge.
You know, you're 33 years old, you're a grown man, you need to move on.
Yes, sir.
And there's a lot of women out there, and you don't need to be concentrating on Miss Davis.
Yes, sir, I can hear you now, sir.
Is there anything you didn't hear?
No, I heard everything. It was just a loud noise back in the background, but I can hear you now, sir.
All right. Mr. Davis, did you understand everything that the DA said?
Yes, sir.
Did you understand all the rights that she read to you?
Yes, sir.
Do you understand that you're giving up your right to appear here in court in person because we can't do that for a little while? And you're choosing to resolve this case over video, Zoom, in order to resolve this case.
Yes, sir.
Is that your wish?
Yes, sir.
All right. Is there any chance of you getting back on with the cab?
Yes, sir.
Have you spoken to your employer over there?
Yes, sir.
Do you have any questions about the litany of rights that the DA read to you concerning your right to cross-examination of witnesses, your right to testify on your own behalf if you chose to do so, your right to have a jury trial? Do you have any questions?
No, sir, I don't have any questions for him.
And are you asking this court to sign your name to the bill of indictment, and I will initial it with my initials? Is that what you'd like for me to do?
Yes, sir.
And Ms. Crawford, is that your understanding as well?
Yes, Your Honor.
All right. When's the last time you were on probation?
You said what now, Judge?
When's the last time you were on probation? When did you get off probation?
I can't remember the exact day, sir, but it's maybe 8 to 10 years.
So it's been 8 to 10 years since you were last on probation?
Yes, sir.
Judge, Ms. Pretty is present. She can probably advise the court.
Okay. Ms. Purdy, what do you show?
What I'm showing, Your Honor, good morning. He is currently on probation on 09 SC 82872, and that case doesn't expire to 2030. He was sentenced by Judge Lovett in 2010, and he's had a revocation where he was continued on probation. So,
All right. Mr. Holmes, on
Yes, sir.
Bill of Indictment 20 SC 176091, as to one count of aggravated stalking, I'm going to sentence you to 5 years to serve 18 months. I'm going to commute the 18 months to time served, and the balance will be placed on probation to run concurrent with any probation you're currently serving.
Oh, what do that mean, sir?
It means that I cut $5, 5 years off the recommendation that was reached by your attorney in the state off your probation, because you're on probation for another 10 years anyway. So you're going to get out of jail within the next 24 hours.
Yes, sir.
And you need to report to probation as you're directed to. You need to stay away from Miss Davis. You need to stay away from Mr. Miller and move on, go to work, go home and stay safe and stay away from drugs as well.
Sir, I haven't did any drugs for a long time, sir.
Okay, I'm giving you a shot. I hope you're successful.
So he said, can I ask a question, sir?
Yes, sir.
You said what was it again? If I couldn't hear you because there's noise in the background.
Okay, 5 years to serve 18 months. I'm going to commute the 18 months to the time that you've served thus far. Okay, you've been in jail for a little over 13 months. So I'm giving
Yes, sir.
I'm giving you some credit there. You
Okay.
got 3.5 years on probation with me, but you're still on probation from Judge Lovett's case for another 10 years. Do you understand that?
Yes, sir.
Have any questions?
No, sir.
Would you
Judge,
like to?
I have a question. Are we revoking and continuing him on probation?
I'm not doing any, he's already, it sounds like he's already been revoked and continued on it.
Is that correct, Ms. Pretty?
Yes, he had a revocation in February of last year, and he was continued on probation. She revoked a little time, but he was continued on probation from that revocation.
All right.
So
Officer Pretty, do you mind?
Yes.
I'm not sure what your practice has been over these Zoom hearings. Can you give him reporting instructions before we end the
I
Zoom?
can.
Okay.
Yes. Mr. Holmes, you need to report to the, can you hear me, Mr. Holmes?
Yes, ma'am.
Okay, you need to report to 276 Memorial Drive on June the 9th.
June the
At
9th.
10 o'clock. Yes,
June the 9th at 10 o'clock, ma'am.
at 10 o'clock a.m.
Yes, ma'am.
Okay, and they will get all this information, so they'll be waiting for you.
Yes, ma'am.
All right, and make sure you have your mask on when you go.
You said my mask?
Yeah, make sure you have a mask. They'll have one for you.
Yes, ma'am.
June
Right.
the 9th.
I can't hear, ma'am. I'm sorry. It's just noise in the background.
June the 9th. Don't forget that date.
You said June the 9th?
Yes.
Okay.
And Mr. Holmes, I'll email that information to your family as well, so they'll also have that
Yes,
date and
ma'am. Hey,
All right.
Miss, can I? Hey, excuse me, Miss Crawford.
yes.
Molly said she been trying to get my phone from the annex building, and they said they still would not never release it.
All right, Mr. Holmes, we'll talk about those types of issues when we're not in court and on the record, okay? I'll reach out
Yes,
to your family and be in touch after this hearing, okay?
Yes, ma'am.
All right. Good luck, Mr. Holmes.
Thank you.
Judge, was that everything?
I believe so.
The state, I think the state has a motion to null pros 19 SC 167274.
Okay.
And is he accepting the plea, Judge?
I beg your pardon?
Is he accepting?
Yes, he's accepting the plea. But Mr. Holmes, also want to instruct you that you have 30 days if, to appeal this hearing. And if you wish to do so, you need to speak to your attorney about that.
Yes, sir.
Anything else?
No, sir.
All right. Thank you.
Thank you.
Yep.
Thank you, Judge.
Thank you.
That concludes my business. May I be excused?
Yes, ma'am. Thank you very much.
Thanks,
Maybe-
Natasha.
Bye. Thank you.
All right, thank you.
Who's next?
Ms.
We got
Simpson?
Miss Jasmine Evans. Miss Jasmine Evans. I don't know what position number she is.
Okay. Yes, Judge.
I have the files that the deputy kindly ran over and got for me. And I'm missing Mr. Holmes' 091 case, but I will get it today. For some reason, it didn't make it in the package.
Okay, I'll check on that as well, Judge.
Okay, but I have the case that we're going to null pros.
Yes, sir.
All right, what's next? Miss Jasmine?
Yeah,
Position,
Miss Evans is mine.
position number 11.
Yes, and this is ADA Chanel. I'm the ADA on that case, and I'm ready.
Okay. All right. Let's go ahead.
Melanie, the ADA's name is in the comments on all of these cases.
Is this Ms. Cabrera?
That's mine, Judge. How are you?
How are you? You've been doing some cycling?
The second,
Yes, you know I have.
Good. I've done a little bit too.
I was going to ask. That's all I've been doing is riding my bike.
Yeah.
can we
What's going on, Melanie?
this is number what, I'm sorry?
This
11.
is number 11.
Number 11. Okay, and I see a DA. Thank you. Okay,
All right, Ms. Chanel,
Yes, Judge.
you may proceed.
Thank you, Judge. This is position 11, Miss Jasmine Evans, indictment number 19 SC 172402. Miss Evans, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before the court should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. Before we begin the plea, defense counsel, Ms. Cabrera, have you discussed today's proceedings with your client, Ms. Evans?
I have.
Does your client fully understand that she will be appearing via Zoom and not present in the courtroom?
Yes, she's aware.
Did you obtain a waiver?
I did. I went in person and got one on the 14th.
Was it verbal or written?
Written.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes. So waived.
And Ms. Evans, have you discussed today's proceedings with your attorney?
Yes, ma'am.
Has your attorney explained to you that you have the right to be physically present in the courtroom?
Yes, ma'am.
Do you waive your right to be physically present in the courtroom?
Yes, ma'am.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, ma'am.
Your Honor, the state also waives an original signature on the indictment and authorizes the court to sign on this behalf.
All right, thank you.
Thank you. Ms. Evans, we will now begin the litany. Can you please state your true, correct, and legal name?
Jasmine Aisha Evans.
Are you I'm sorry, can you spell your middle name?
Iesha.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
I'm 34.
How far have you gone in school?
11th grade. I made it to the 12th, but I didn't return.
Okay, did you get a GED?
No, ma'am. I'm working on that.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with one count of aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Cabrera, about all the facts and circumstances known to you regarding the charge of this indictment?
Yes, ma'am.
Did you all also talk about potential defenses?
Huh?
Did you all discuss potential defenses?
Yeah.
Do you need more time to discuss the case with your attorney?
No. I trust her.
Okay. And are you satisfied with her services?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes. So waived.
Do you waive any and all defects in the indictment, including with respect to your name?
Yes. Also waived.
Were you arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No. No warrants.
Has your attorney advised you as to the minimum and maximum sentence for the charge of pleading?
Yes.
Aggravated assault is punishable from 1 to 20 years in prison.
All right,
Hold on.
repeat the last
low.
I'm sorry, I can't hear you.
In the middle of a court now. You don't want them to call you back.
now.
All right.
Somebody's talking.
Miss Melanie, you're breaking up and South
Okay,
hear the deputy behind.
Yeah,
all right, I can hear you.
yes. And can the DA repeat the last question? And there's noise, and so that's making the DA break up for me. So,
Yes.
yeah.
Okay. Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes, ma'am.
So waived.
Do you waive any and all defects in the indictment,
Yes.
including with respect to your name?
Yes, ma'am.
Also waived.
Were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No.
No warrants.
Has your attorney advised you as to the minimum and maximum sentence for the charge you're pleading to?
Yes. Yes.
Aggravated assault is punishable from 1 to 20 years in prison. You understand that sentence?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
That means that the state will recommend to the court a sentence of 4 years to serve 1 year in prison with a balance on probation.
Yes.
Do you understand that the court does not have to accept this recommendation?
Right.
Do you understand that the court can sentence you up to the maximum allowable by the law?
Yes.
Do you understand that this plea may be used to enhance sentencing on future convictions if you have any?
Yes.
And that goes for this jurisdiction as well as outside jurisdictions.
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today?
Yes, ma'am.
And I know that Ms. Evans is on probation.
I'm on probation.
You are probation?
Yes, ma'am.
Okay, I apologize. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked?
Yes.
Do you understand that you're not allowed to use or possess a firearm while you're on probation?
Right. Yeah.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transfer a firearm, or the ability to obtain employment. You understand these rights?
Yes, I do.
And you understand that they may be impacted by you pleading guilty today?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had at a trial?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to the presumption of innocence, the right to testify. Excuse me. The right to the presumption of innocence, the right to testify on your own behalf, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand these rights?
Yes, ma'am.
And you understand that you've given them up by pleading guilty today?
Yes.
Has anyone forced, threatened, or promised you anything?
No.
No, wait until the question's asked, please.
I'm sorry.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, no, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty? Do you need me to reread the question?
What, ma'am, what you say?
Okay, I'll read the question again. Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to charges of aggravated assault and indictment number 19 SC 172402?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether this plea was voluntary?
Okay. Yes.
Thank you. And I'll go through your criminal history now. Okay, Judge, Ms. Evans has 4 prior felony convictions. She has an ag assault out of Fulton adjudicated in 2018, a possession of cocaine out of Fulton adjudicated in 2016, a possession of cocaine out of Paulding County adjudicated in 2009, and a burglary out of Fulton adjudicated in 2006. Had this case gone to trial, the state would have shown that in 2019 in Fulton County, Georgia, the defendant, Ms. Evans, attempted to stab her former boyfriend, victim, Mr. William Thomas. She attempted to stab him multiple times with a knife. The knife had a blade of less than 3 inches. When the officer responded to the scene, the victim told the officer what happened. He stated that he wasn't actually stabbed, but the officer could see that his clothing had been sliced. At the time of this offense, the defendant was already on probation for attempting to stab the same victim, I believe a year prior. Nothing further from the state at this time.
All right. Ms. Evans, did you understand all the rights that you're giving up or waiving by entering this plea today?
Yes, sir.
Do you have any questions about any rights that you're giving up or waiving?
No, sir.
You understand that the court, with your permission and that of your attorney, has signed your name. I don't know if you can see it, but I've signed your name and your attorney's name and the DA's name on this bill of indictment, which is the official charging document. And down below, I've written by H.M. Newkirk, that's me, Zoom, which indicates this was a Zoom hearing. So is this the way that you'd like to conclude this hearing as opposed to waiting to come to court in person that could be some months away?
Yeah. Yeah.
All right. Defense counsel, Ms. Cabrera.
Yes, Judge. So Miss Evans there's a history of drug abuse, and there's some mental health concerns. And so right now she has a son who's living with her aunt, but she had a mother, her mother passed in May of last year. And at the time, but prior to her mother passing, she was actually being treated at Grady through that ACT program. She also received treatment at Georgia Baptist. And at this time, her family is hoping that she can kind of continue on the path to receiving proper treatment. I think she can be at least placed with somebody through probation that can supervise and make sure that she's receiving treatment as she was once upon a time before. Her family does want her to come home. She also had a affidavit that was sent to me by the victim, William Thomas. The relationship is not a healthy one, but he did write a letter on her behalf explaining that they did have a misunderstanding. I did give that to the state, so she has a copy, that he didn't want to go forward, but he wanted her to receive some form of drug treatment. I'm asking that Your Honor accept her plea as negotiated, and that she be assigned the proper probation officer to make sure that she stays on track.
All right.
She's been in custody actually since September. I'm sorry, Your Honor, since September of 2019. So I'd be asking that her year be commuted to time served as opposed to credit for time served.
Ms. Purdy, is Ms. Evans currently on probation?
No, Your Honor, her probation actually expired in December of last year.
Okay, and what's the prospect of having any further contact with William Thomas, which I'm going to order her not to have?
Right. I don't want I don't want any more contact with him, sir.
Okay, do you understand that a term of this sentence is going to be not to have any further contact with William Thomas?
Yes, sir. I'm really done with that relationship. I mean, it really wasn't healthy. And me being here is giving me a lot of time to sit and think that my family and my son needs me more than anything. And I'm so glad that I'm really able to go home to my family now. I think that's why me and him stayed together so long, because I had a fear of my family not wanting me at home. But it was just something that my mom was going through. And that was the reason why I couldn't go home. So now that my mom has passed,
Judge, what she hasn't mentioned is that she couldn't go back home because her mother had battled kind of the same issues before. So to have her daughter in the home with her would only trigger her and put her back in the same place that she was. So Miss Evans was forced to not be at her home, which made it easy for her to maintain a relationship with Mr. Williams.
Right.
But her mother since passed, and her aunt will have her home.
Judge, and if I may, the state is opposed to commuting her time to time served. Miss Evans also has an open case that's not indicted yet, but it's a battery that's going to be upgraded to an aggravated battery. The victim in that case was a worker at a homeless shelter where Miss Evans was staying. The victim in that case was attacked by Miss Evans. She's going to require surgery on her neck, and she had a broken bone in her leg, I believe.
That's not true.
I did speak to that victim on Friday, and she is afraid of the defendant, Miss Evans. Miss Evans, after the attack, Miss Evans ran from the shelter. She was missing for about 4 months before she was arrested for that attack. During that time, she did tell me that she would retaliate against the victim the next time she saw her.
I'm sorry, excuse me, there was over talking, so I need the DA to repeat the last.
Miss Evans, when somebody else is speaking, please don't speak over them. We'll give you plenty of time to say anything you want to, okay?
And can I repeat that I heard that the victim was afraid? If you can pick up.
Yes, the victim was, I spoke to the victim in the new case on Friday. She is afraid of the defendant. When the defendant attacked her, she fled from the homeless shelter, so she wasn't arrested for 4 months. And in between that time, the defendant had been telling people that the next time she saw the victim, she wasn't going to have a chance to call the police, basically that she was going to harm her again. So the victim in that case is very fearful of the defendant. So Miss Evans has 2 violent cases open right now. She just finished a probation for aggravated assault in December of 2019. It's the state's position that Miss Evans is violent and a danger to the community. Therefore, we would be opposing that her time be commuted to time served.
When did that other offense allegedly occur?
Let me look it up, Judge. It was just transferred to the state on May 12th of 2020, but let me look up when the offense occurred.
It obviously occurred sometime prior to September 1st of 2019.
Correct. And that case was in state court. Initially, they had offered her, I think it was 2 months to serve, and then that changed to 6 months to serve, and then she was supposed to take a plea on it about a week ago. Went in for the plea, and when they got there for the plea, the state announced that they were transferring it. So she had another attorney that was involved to kind of let me know in advance, and we did what we could so that we could try to at least get it resolved today with this. But it's not possible to get that new case number in time.
Okay, so the date of the report is September 24th of 2019. And I believe the case didn't plead in state court because they didn't realize the severity of the victim's injuries. And we're currently waiting on medical records from the victim. When I talked to her on Friday, she said she would be sending them shortly.
All right. Anything else anybody would like to say? All right,
Nothing
Ms.
further, Your
Evans.
Honor.
Ms. Evans,
Yes, sir.
you have some problems with your lashing out behavior. For whatever reason, you need to seek out and take some anger management courses that will give you some techniques to help you deal with your anger when things don't go your way. But picking up a knife is not the way to do it. And if you pick up a little penknife that has a 1-inch blade and you hit somebody in the wrong place, like on the side of the neck, you can kill them in a heartbeat. They'll bleed out. You hit the carotid artery. And I'm sure you wouldn't necessarily intend to kill them, but that's what happened. And then you're gone for the rest of your life. So lashing out at people physically with objects or with your hands is unacceptable. And you've got to control that. If you have some issues that need to be dealt with by medical professionals, you need to go to appointments. You need to take the drugs they tell you to take and nothing else, and stay on it. But the current path that you're leading is not going to be very favorable for you if you continue to be involved with the justice system on assaults. And it's obvious that you need some help to get you through that, but at the end of the day, it's up to you. Do you understand that?
Yes, sir.
So you have some other issues coming up. Based upon what I've heard on this case and not sentencing her for the next case, I'm going to sentence her to 4 years to serve 1 year. I will commute the 1 year to time served based upon the over 9 months that she served. While on probation, I'm going to request that you be assigned to mental health probation.
Yes,
You
yes,
attend all your medical visits, take the drugs you're prescribed and nothing else, and not have any further violations of the law. And I would also recommend that you are ordered that as a part of this probation, you take and complete an anger management course. And probation can help you find one. You still have to deal with the other case that's coming down the pike. And I'm not sure what kind of bond you have on that. So you're not out of the woods yet, but this case is taken care of. Is that your wish to proceed with this case alone today?
yes, sir. But I was hoping I could take care of the other one too, but I guess I can't.
No, you can't do that today. The state's not ready. The state has to present it to a grand jury, and grand jurors can't be impaneled right now because of the COVID virus.
Your Honor, I want to say I did not flee from the shelter. I was asked to leave the premise.
All right.
And I did not attack her.
All that will come out at a different hearing.
Yes, sir.
Based upon the sentence that I've given you, is it your intent and wish to stand by your plea and accept the court sentence?
Yes.
Hold on, Nicole.
All right, you have 30 days from today's date.
Excuse me, Judge. I'm sorry. Miss Chenault had got kicked out. She's asking if you guys can let her in.
She's in.
Hey.
She needs to unmute her mic.
No, she's coming in now. It looked like I think hers had gotten frozen or something. She's coming in now.
Okay.
Okay, I'm going back away.
All right.
I'm back. My internet went out, Judge.
Okay. I don't think you missed too much. Miss Evans.
Yes, sir.
Good luck to you. And you have 30 days from today's date to file a notice of appeal if you wish. And you have until the end of the term of court, which is the end of this month, to file a motion to withdraw your plea if you wish to do that.
Okay, so if I bond out on my other charge, I'll be able to go home today?
Yes, ma'am.
Okay, thank you.
And you need to report to probation. Ms. Pretty, do you have any directions for her there?
Yeah, that's what I was going to ask you.
On June the 9th at 10 o'clock, Report to 276 Memorial Drive.
Okay, June the 9th.
Ms.
I have to
Cabrera,
write that down.
Ms. Cabrera, will you memorialize that and send to her?
Yes, I will. I'll make sure she gets something.
And Miss, can you call my aunt and let her know? the
I've already
date of-
contacted her.
You did?
I
Okay.
did.
All right, good luck to you.
Thank you.
Who's
Ma'am.
next?
Is it 9?
See Jacob Lowe there too.
Who's the next defendant?
Position 9. Mr. Lowe?
Jacob
Position-
Lowe, that's mine.
Okay. Position number 9, Melanie.
Okay, give me 1 second to get there.
Okay, I'm gonna need 1 second too, please.
Okay,
I'm ready whenever. Thank you.
Okay, and this is gonna be with Maxwell. Maxwell, you ready?
It's mine.
Okay,
Jacob Lowe is mine.
okay, got it. Oh, I'm sorry. I'm looking at the wrong thing.
Mhm.
And this is, who's the ADA on this case?
Kiana, Miss Chenault.
Okay, gotcha.
I am. I'm trying to get into my work computer. 1 second.
So Melanie, the prosecutor on this case, in the comments, it has euphemia, but it's not euphemia. The prosecutor on position number 9, or actually, no, it doesn't. I'm sorry, my calendar is cut off.
Right, yeah, I'm good. It's got it.
Okay, good.
Yeah, thank you.
Okay. All right. Who has this Miss Denise case? Who is she a victim in a case or something? Does anybody know? Okay, Miss Denise doing the most.
I think it might be my client's mother. I think it might be Denise Leachman.
Okay, well, she's got a lot going on.
Well, yeah, that's what makes me think it's her.
Okay.
It's Marquise Murray's mother.
Okay.
Also, Ms. Simpson,
Yes.
just so you know, Marquise Murray, I was told is in quarantine because he has COVID. I don't know if that's true or not, so they may say he's unavailable.
Okay, all right. Okay. Okay, that'll be fine. Miss Denise, can you unmute your mic, please?
Yes.
Can you kind of cut the movement down, please? This is an actual court hearing.
What movement? I had it on mute like you asked me. I ain't making no movement.
Okay, mute your mic.
All
And
right.
if you could refrain from moving around.
Marion, may I ask that the DA spell any victim names that come up, either during the plea or after the plea's over, since I can't access that.
So Ms. Chenault, if you could do it during the plea, so it'll be on the record.
Yes, I got it.
Thank you.
Okay, thank you for being patient. I'm ready, yes. Okay, so this is Mr. Jacob Lowe.
okay.
I'm just pulling up his indictment. Position number 9, indictment number 19, SC 172800. Mr. Lowe, are you ready?
Yeah.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Defense counsel, Ms. Cabrera, before we get started on the litany, I just want to ask you a few questions.
Okay.
Have you discussed today's proceedings with your client, Mr. Lowe?
Yes.
Does your client fully understand that he will be appearing via Zoom and not be present in the courtroom?
He's aware.
Did you obtain a waiver?
It's a verbal waiver. I've spoken to him. I speak to him a couple times a week. So he's waived his right to be in the physical courtroom for the hearing.
Okay. And do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes.
Mr. Lowe? Are you muted? I didn't hear you.
Yes, ma'am. No, I'm not muted, please.
Okay, have you discussed today's proceedings with your attorney?
Yes, ma'am.
Has your attorney explained to you that you have a right to be physically present in the courtroom?
Yes, ma'am.
Do you waive your right to be physically present in the courtroom?
Yes, ma'am.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, ma'am.
Thank you. Your Honor, the state waives an original signature on the indictment and authorizes the court to sign on its behalf as well.
Thank you. You may proceed.
Thank you, Judge. Mr. Lowe, please state your true, correct, and legal name.
Jacob Morlow.
I'm sorry, was the defendant sworn?
I don't think he was.
I don't think he was. He was not. He has not raised his right hand yet. I don't remember that.
Ms. Shinola, go ahead.
Thank you, Judge. Mr. Lowe, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Jacob Morlow.
Can you spell your middle name, please?
M-O-O-R-E.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
42.
And how far have you gone in school?
College.
You graduated from college?
With an associate's degree, and I've been to technical college.
Thank you. Are you able to read, write, and understand English?
Yes, ma'am.
Do you understand that you're being charged with the following offenses: aggravated assault, false imprisonment, possession of heroin, and battery family violence?
That's what I'm charged with. Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Cabrera, about all the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Did you all also talk about potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including with respect to your name?
Yes, ma'am.
Were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No warrants.
Does he have a warrant out of Whitfield County?
He does have a hold out of Whitfield County. He has probation that he has to return and be heard on, a probation revocation.
Thank you. Has your attorney advised you as to the minimum and maximum sentence for each charge you're pleading to?
Yes, ma'am.
Okay, and I'll just review it again with you. Count 1, aggravated assault, is punishable from 1 to 20 years in prison. Count 2, false imprisonment, is punishable from 1 to 10 years in prison. Possession of heroin, count 3, is punishable from 1 to 3 years in prison. And battery family violence is punishable from 1 to 5 years in prison. You understand these sentences?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
That means
Well,
that
hold on, Kiana. It's not exactly negotiated because I think you're going to be asking for him to have 2 years to serve. I'm going to ask that it be 2 years commuted to time served, since I know he still has to return to Whitfield, where they have an exact 2 years hanging above his head where they may hold him for that. So I'm not asking him that he be held on our 2 years.
Okay, so
Okay.
this is the, thank you. So this is gonna be a non-negotiated plea, Mr. Lowe. You understand that?
Yes, ma'am.
It's also going to be Alfred on the counts related to any physical activity or anything. There's a battery charge, a false imprisonment, and an aggravated assault. He just disagrees with how those facts are laid out between him and the victim in that case.
Okay. So, Mr. Lowe, a non-negotiated plea means that the state and the defense could not come to an agreement as to your sentence in this case. Do you understand that?
Yes, ma'am.
Are you aware of the state's offer of 5 years to serve 2 with a balance on probation?
Yes, ma'am.
And did you discuss this offer with your attorney?
Yes, ma'am.
Do you understand that the court can sentence you to any sentence authorized by the law?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on future cases?
I'm sorry, I lost the DA.
Yeah, her internet went out.
Yeah.
Let her know. I sent her a message. She said it's coming back. She's getting ready to re-enter. She's asking to be let in.
Okay, I'm Madam Court Reporter, can you let me know the last question I
Yeah.
asked?
The last full question I heard was, you understand that the court can sentence you to any sentence authorized by the law?
Thank you. And do you understand that, Mr. Law?
Yes, ma'am.
Okay. And you understand that this plea may be used to enhance sentencing on future convictions if you have any?
Yes, ma'am.
And that goes for this jurisdiction as well as outside jurisdictions. Do you understand that?
Yes, ma'am.
As well as, I'm sorry?
That goes for this jurisdiction as well as outside jurisdictions. And you understand that, Mr. Law?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked?
Yes, ma'am.
And just give me a minute. I have to open up the plea with me on my phone. Okay, do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardon and Paroles, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. You understand these rights?
Yes, ma'am.
And you understand that they may be impacted by you pleading guilty today.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering the plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have certain rights that you're giving up today?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to the presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand these rights?
Yes, ma'am, I do.
And you understand that you've given them up by pleading guilty today.
I'm sorry, I didn't hear the last question.
Do you understand these rights, Mr. Law?
Yes, ma'am, I do.
And you understand that you've given them up by pleading guilty today.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
And I believe you're only pleading guilty to one of the charges. Is that correct?
That's correct.
Okay. So I'm going
Correct.
to, Ms. Can you just read the indictment number?
The indictment number is 19 SC 172800.
Okay. How do you plead to the charge of aggravated assault in indictment number 19 SC 172800?
Not guilty.
What he doesn't realize, he has to, you enter your plea as to the charges that you disagree with, enter those as guilty under Alford.
Oh, I got you.
Okay.
Sorry about that.
Okay, so I'll ask again. How do you plead to the charge of aggravated assault in indictment number 19 SC 172800?
Guilty.
Is it guilty under Alfred?
Yes.
Is it guilty under Alfred, Mr. Lowe?
Yes, ma'am.
Are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
And how do you plead to the charge of battery, family violence, and indictment number 19 SC 172800?
Guilty.
Is it guilty under Alfred?
Yes, ma'am.
Are you pleading guilty because you have decided it's in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
And how do you plead to the charge of false imprisonment in indictment number 19 SC 172800?
Guilty.
Do you need me to ask again, Mr. Law?
No, I'm guilty, ma'am.
He said guilty. I heard him.
Okay, I didn't hear him. Is it guilty under Alfred?
Yes, ma'am.
Are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
And how do you plead to the charge of possession of heroin in indictment number 19 SC 172800?
Guilty.
Is it pleading to the heroin charge or to the battery charge?
He's pleading guilty as to the heroin charge. There's, when she goes through the facts of the case, you'll learn that there's involvement with his ex-girlfriend and some of the things that he's alleged to have done to her. He's pleading guilty under Alford as to those charges specifically, but he pleads guilty as to the heroin possession.
Guilty as to heroin and guilty under Alford to all other charges on the indictment?
Yes.
Okay. Thank you for that clarification.
Yes.
All right, Ms. Chenault, anything further?
Yes, Judge. If you would just give me a minute. My computer is coming back up. Okay. Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether this plea was voluntary?
Yes, ma'am.
Thank you. And as far as Mr. Lowe's history, Mr. Lowe has 5 prior felony convictions. He has a conviction for aggravated stalking out of Whitfield County from 2002. He has a theft by conversion out of Catoosa, that's Catoosa County in 2016. He has another theft by conversion out of Whitfield County, in 2016. He has a possession of a controlled substance out of Whitfield County in 2017, and a possession of methamphetamine out of Whitfield County in 2019. Had this case gone to trial, the state would have shown that in 2019 at a In-N-Out Burger in Fulton County, police responded to the scene of a altercation. When they got there, they found the victim, Miss Monica Dodd, it's Monicadadd. She was passed out in the bathroom of the restaurant. When she was revived, she did report that the defendant, Mr. Lowe, kept her locked in his car outside in the parking lot. While they were in the parking lot, the defendant did stab her in the thigh with a heroin needle, injecting her with heroin. Ms. Dodd then fled to the bathroom inside the cookout, and she collapsed on the floor. It was there that the police found her, and she gave them that story. Mr. Lowe was then arrested and charged accordingly. And nothing further from the state.
All right, Mr. Lowe, did you understand all the rights that the DA just reviewed with you?
Yes, sir, I do.
You understand that you're giving up your right to appear in person here in court as well?
Yes, sir.
Yeah, I'm holding up the indictment that I have signed your name to. Let me see if you can see it. I signed your name and your attorney's name and the district attorney's name, and I will sign my name down below as having signed for you with your express permission. Is that correct?
Yes, sir.
But you understand that you're giving up your right to trial by jury, your presumption of innocence,
Yes,
your
sir, I
right
do.
to justify in your own defense,
Yes, sir.
entering this guilty plea. Ms. Cabrera?
Yes, Judge. So Mr. Lowe has been in custody, I believe, since October of last year. Yeah, it is October 21st of 2019. We entered some of those charges as guilty under Alford. At the time, he was in a residential treatment facility. He had been dating Miss Monica Dodd since prior to that summer. She gave him a call, told him about coming into the city. He came into the city, met up with her. Unfortunately, they did get involved in drug use, which was definitely outside of what he was supposed to be doing in his treatment program. He did have a curfew. He figured he could make this spin around, go out there, I guess, ultimately get high, turn around and come back. I think Ms. Dodd told him that she wanted to come back out to Dalton as well. So he had the impression that he was going to be picking her up and bringing her back out. He has maintained since arraignment that he didn't forcibly inject any drugs into her or anything like that. And he's never wavered on that at all. This has always been the case, that if anything, you know, she did that herself and then went into the restaurant. When the ambulance or the police arrived, he was actually asleep in his car. They had to knock on the window to wake him up when they picked her up and responded to getting her. And then he was arrested at that time for what she said had happened. So I know that the state and I, we've been working on this for the longest time, trying to get this case resolved because he was interested in going on ahead and having a trial. I did speak to his attorney out in Whitfield County. He does have open probation out there, and he has a revocation where there is a 2 years that's hanging over his head that they're very likely to hold him in custody for, since they were not so pleased with him making this journey into Atlanta, and another concern about you know, just the usage of an ankle monitor. So the state is asking for 5 years to serve 2. And that being credit for time served, I'm asking for it to be 5 years to serve 2 commuted to time served, since I know upon release from Fulton County, he's going to spin around and only be transported directly to Whitfield, and he will not be released in order to do that.
All right, Ms. Pretty?
Yes, Your Honor.
What do you show?
He is on probation on 4 cases. The one out of Catoosa County, that probation case ends November the 1st of 2021. The cases out of Whitfield County, 16 CR 01637, that expires 3/1/26. 19 CR 01276-B, that expires 4/10/25, and 17 CR 00541-B expires 2/28/29. So he has a lot of probation remaining out of Whitfield County.
And
one other thing, Your Honor, I didn't tell you. So Mr. Lowe, he has a history that seems pretty lengthy. But before he had started with any drug use, he did go to a technical college and he had his own business. And so I've had a lot of time to talk with his family and even people in the community that where he was in Dalton. He ran his own business, was successful, had pretty good relationships there. He still has really good relationships there. They still call and check on him through me to find out what's going on. So people are genuinely concerned about him and what happens with him. But that they said, you know, when he's turned to drugs, that his business took a dive after that. And so he's been in this rut since his drug usage.
Mr. Lowe, do you live in Whitfield or Catoosa?
I live in Whitfield, sir.
What type of dwelling do you live in? Apartment or a house or with family?
House.
And
with family at this time, sir. I sold my home almost 2 years ago after divorce.
All right. And do you have children?
No, sir.
And tell me again what type of work you do?
I do heating and air conditioning, electrical. I'm state licensed.
And how long you been fighting the battle with drugs?
It started in the early 2000s, and I got clean for nearly 10 years, and I've been since about 2014, 15 fighting the opiate stuff, the pain pills to the heroin.
Yeah. And what type of probation were you on at the time that this occurred? Were you on ankle monitor and supervised release?
I was on ankle monitor to supervised released into a drug treatment program, Carter Hope in Dalton, Georgia.
And you absconded from the treatment program?
I had permission to be gone during the curfew hours, but I came to Atlanta to pick up Monica Dodd, and end up, when I was here, I messed up, and here I sit. She was supposed to be coming back to Dalton and to try to get help, and I tried to throw a life raft, and here I am. The life raft pulled me in with it.
Yeah,
I should have stayed in Dalton.
And how long have you and Monica been together?
Off and on since January of 2019. 19, I guess. But I've been incarcerated the majority of that time, so it's not like we've really been in much of a relationship.
Is there any quest for him not to have any contact with her?
No, Judge. I actually spoke to Ms. Dodd on Friday. She is in custody in Union City Jail. And she expressed her desire not to press charges, and she still wants to be with the defendant. So there's no request for no contact.
I noticed that Miss Dodd is from Daisy, Tennessee. I've never heard of that town.
You've heard of Chattanooga, sir. Her dad's a retired police chief of the city of Chattanooga.
Really?
Yeah, Bobby Dodd.
All right. Mr. Lowe, it sounds like you have a degree of intelligence above that of normal person. You've done well in heating and air. You got to have some brains to do that. I hope that you extend your knowledge into addiction and how to get out of it. You've got another 30, maybe 40 years to live if you stay clean and take care of yourself. And you're not doing yourself or your loved ones any good by being in prison.
Yes, sir.
Is there currently a hold on you?
Yes, sir.
Okay. All right, Mr. Lowe, I'm going to sentence you to 18 months. I'm going to commute the 18 months to time served and allow Katusha to get you back. And good luck to you.
Thank you very much, Judge.
Mr. Lowe, you have 30 days from today's date to file a notice of appeal if you wish to do so, and you have to the end of this term of court, which is the end of April, to file a motion to withdraw your plea if you wish to do so. Do you understand that?
Yes, Your Honor.
All right. Good luck to you, sir.
Judge, I have a question. Is that 18 months commuted to time served as to each count?
That would be affirmative.
Okay, thank you. Who's next?
You have position 10, Jarvis Thomas.
Get all mine back to back. That's me again.
All right. We're going to take this plea and then take a 5-minute stand up, shake your arms and legs out and break.
Yeah, it's negotiated though, so
Okay.
nothing special.
Judge,
Right.
you always got to incorporate some exercise.
Well, it's been an hour and a half. I mean,
You on a ball?
this is about the only movement I have.
Jeez. Always got to exercise.
Well, we can exercise on Zoom. We can reach for the sky, roll our arms.
No.
I have a question. Position 10 is what we're doing next?
Yes.
Is that right? Okay, I do not see a DA for that one.
It's Miss Chenault again.
No, okay.
Same attorneys this time.
Thank you.
All right, this is Mr. Jarvis Thomas.
Yes, Mr. Jarvis Thomas, indictment number 17S172430. Mr. Thomas, are you ready?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Ms. Cabrera, before we get started, have you discussed today's proceedings with your client, Mr. Thomas?
Yes, I've spoken to, I had to reach out to him through the floor, but I clarified that he understands he's doing this by Zoom, and he understands what his offer is and everything, and that it's a negotiated plea. I think he's clear, and he's waiving the need to physically sign his indictment or to be present in the courtroom.
Okay, and you got a verbal waiver from him as far as waiving his right to be in the courtroom?
Right.
Okay. And Mr. Thomas, have you discussed today's proceedings with your attorney?
Excuse me?
Have you discussed today's proceedings with your attorney?
Yes, ma'am.
Has your attorney explained to you that you have the right to be physically present in the courtroom?
Yes, ma'am.
Do you waive your right to be physically present in the courtroom?
Yes.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, ma'am.
Yes.
Thank Your Honor, the state also waives an original signature on the indictment and authorizes the court to sign on this behalf.
All right, thank you. You may proceed.
Thank you, Judge. Mr. Thomas, please state your true, correct, and legal name.
Jarvis Thomas.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't been given today?
No, ma'am.
How old are you?
I'm 25.
And how far did you go in school?
11th grade.
Did you do GED?
No, ma'am.
Are you able to read, write, and understand English?
Yes, ma'am.
Do you understand that you're being charged with the following charges? Aggravated assault, possession of a knife during commission of a felony, and aggravated family violence.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Cabrera, about all the facts and circumstances known to you regarding the charges in this indictment?
I still want to speak with her about it some more.
Can we do a breakout room?
Yes, Judge.
All right, let's do a breakout room and give defense counsel a moment to speak to her client.
Yes, Judge.
Okay, we'll give them 3 minutes if y'all want to stretch your legs for a minute.
Okay.
Thank you, Judge.
All right.
I'm gonna walk away for just a second. I'll be right back.
That's fine.
Okay.
Sure, 3 minutes.
I'm sorry, who's going into the breakout room with the inmate?
Cabrera. It should be Ms. Cabrera.
Right. It says E. Demore.
Ms. Chenault, you usually in Joshua?
I am, yes.
Okay, good to meet you.
Good to meet you as well. How you doing today?
Doing good. Want y'all to hurry up.
Keep working. It's like tripping today.
Right. Look, we don't have time for no breakout rooms. Let's roll.
I agree on that.
Right, Ms. Hall.
Ms. Simpson?
Yes, Max.
Hey,
Max.
so on the instructions, it told us to call the jail the day before the court, and they weren't picking up yesterday. So I tried, and my clients have a general idea of the plan, and I also called their mothers that maybe it could get explained when they called home tonight. But I might need to just, I probably don't even need a breakout room, but I just might need to make them aware, because I wasn't able to have that conversation yesterday when I called.
That makes sense. No problem.
All right, cool.
I'm just being funny anyway, because they instructed us that, you know, they sent an email saying that the Zoom hearings should be straight to and move on. But I know it's stuff that you all have to do, so I'm not concerned.
Yeah, when I call a random number at the jail, there's usually about a 3% chance that someone actually answers it. So, all
That's not a problem.
right.
Yep, you're good, Max.
All right, excellent.
Look, I'm telling you, I already got the dispositions done so far. You heard me, Mel?
You have it done?
I've already done the dispositions, yeah, all the way up until now.
How many more do we have? Do you know?
18.
1, 2, 3. Maybe about, let's see, 1, 2. We got 3 more defendants to see after this guy. No, 4 more defendants to see after this guy.
It's not bad.
Yeah, we're probably the best that have ever done it.
Is Madam Probation there?
Miss Pretty is there, yeah, Miss Pretty.
Miss Pretty, does this defendant have an open probation?
No, his probation ended in 2018, but he did have a first offenders where he had robbery, and that ended in 2017.
Okay, just checking. Thank you.
You're welcome.
All right, are we ready for the DA to continue with the litany of rights?
We're ready.
Mr. Jarvis, have you had a sufficient amount, or excuse me, Mr. Thomas, have you had a sufficient amount of time to discuss your case with your attorney?
Yes, Your Honor.
Do you wish to proceed with this Zoom
Yes, Your Honor.
plea?
Yes,
All
Your
right.
Honor.
All right, counsel.
Yes, Judge, thank you. Are you satisfied with your attorney's services?
Excuse me, I can hear you, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your name?
Also waived.
Were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No warrants.
Has your attorney advised you as to the minimum and maximum sentence for each charge you're pleading to? Mr. Thomas?
Ma'am.
He was told at arraignment.
Okay, I'll just repeat the sentences you will be facing if you went to trial. So you would know, so you know that, okay?
Yes, ma'am.
Okay, so aggravated assault, family violence is punishable from 3 to 20 years in prison. Possession of a knife during commission of a felony is punishable from 1 to 5 years in prison. And battery family violence is punishable from 5 years in prison. You understand these sentences?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may risk jury trial?
Yes, ma'am.
Okay, do you understand that this is a non-negotiated plea of guilty?
Yes.
That means that the state and the defense cannot come to an agreement as to your sentencing. You understand that?
You kind of breaking up. I can't hear you.
That means that the state and the defense cannot come to an agreement as to your sentence in the case.
Yes, ma'am.
You understand that?
Yes, ma'am.
Are you aware of the state's offer of 5 years to serve 1 with the balance on probation?
Yes, ma'am.
And did you discuss this offer with your attorney?
Yes, ma'am, I did.
Do you understand that the court can impose any sentence authorized by law?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on future convictions if you have any?
Yes, ma'am.
And that goes for this jurisdiction as well as outside jurisdictions. Do you understand that?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering the plea of guilty?
Yes, ma'am.
Do you understand If you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked.
Yes, ma'am.
You understand that you're not allowed to use or possess a firearm while you're on probation.
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes, ma'am.
For example, the guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand these rights?
Yes, ma'am. I understand.
And you understand that they may be impacted by you pleading guilty today.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had at a trial?
Yes, ma'am. I understand.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to the presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after. Do you understand these rights?
Yes, ma'am. I do.
And you understand that you've given them up today guilty.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How to the charges of aggravated assault, family violence, possession of a knife during commission of a felony, and battery, family violence, and indictment number 19 SC 172430.
So how do I plead it?
Yes, how do you plead to those charges?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether this plea was voluntary?
Yes, ma'am.
Thank you. Judge, the state notes that Mr. Thomas has 2 prior felony convictions. He has a criminal damage to property in the 1st degree out of Fulton and a burglary the 2nd degree out of Fulton in 2014. I'm sorry, damage was in 2016.
You're breaking up.
Okay, Mr. Thomas,
Okay,
the criminal damage. Can you hear me now?
Yeah, I was going to let you know, I heard up to, and a burglary in the 2nd degree out of Fulton in 2014, if you just want to pick up there.
Yes, and the criminal damage to property was out of Fulton, and that was adjudicated in 2016. And those are his only 2 felony convictions that I have. Ms. Pretty, do you see any other felony convictions?
No, I do not. As I said, it was a first offenders for robbery by intimidation, possession of firearm during the commission of a felony, and possession of marijuana. And that was in 2013.
Thank you. Ms. Cabrera, he has to go to the cab as well?
He does. He has an open DeKalb County case. He has a FTA to respond to there, and then that case has to be handled.
Do you know
The
what the charge?
FTA, I don't remember. We can ask him, but the FTA is related to It happened during the time that his grandmother passed and her funeral and everything. So he was aware of the court date, but he didn't make it. But it's still something he's going to have to go to DeKalb County and give them proof of to respond to.
Does he have an open case in addition to the FTA?
He does.
And what's that case?
Mr. Thomas, what are those charges?
I had the domestic violence, simple battery. I have 3 counts of obstruction.
Okay.
Okay.
Is it the same victim?
No, ma'am. No.
All right, go ahead.
Okay, thank you. Had this case gone to trial, the state would have shown that on September 27th of 2019 at 138 Griffin Street in Fulton County, the accused, Mr. Thomas, became angry with his mother, the victim in this case, Miss Stacy Middlebrook, and her name is spelled Stacey. Middlebrooks is Middlebrooks. The defendant became angry with her because she flushed his in the toilet.
I'm sorry, what?
What did she flush down the toilet?
I lost her at flush.
The victim flushed his cocaine in the toilet.
All right.
The
Can you
defendant
all,
then got.
Ms. Chanel, I'm sorry. Mr. Thomas, can you get the officer in the jail, please?
He's here. Yes, ma'am.
Okay, so our court reporter is trying to hear the proceedings with your background. It's difficult. And I understand you're at the jail, but if they can just quiet it down a little bit.
Yes, ma'am. There is the floor officers, and they're feeding and things, so they got to open up the doors. I will inform them to quiet down a little bit for me.
Okay, thank you. Thank you so much.
Thank you, Terry. But also, Ms. Schmaltz is breaking up a lot, so that's why I'm keep having to interrupt.
Okay. I'm sorry about that. My internet decided to go out today, so I'm calling from my phone.
Yeah.
So thank you for being patient.
Mm-hmm.
Okay. After the victim, Miss Middlebrooks, flushed the defendant's cocaine down the toilet, the defendant retrieved 2 butcher knives with blades in excess of 3 inches and tried to stab Miss Middlebrooks with the knives. The defendant was living in the same residence with Miss Middlebrooks at that time. The defendant's uncle, Mr. Brandon Middlebrooks, also got involved in the altercation. During the altercation, the defendant did strike Mr. Brandon Middlebrooks in the lip, causing him to suffer a laceration. The officer then arrived on the scene, and the defendant had left the scene by the time the officer had arrived, but the officer did speak with both of the victims, and they told the officer what happened. The officer then obtained warrants for the accused based on.
Did Mr. Thomas live at his mother's house at the time?
He did, Judge.
All right.
Nothing further from the state at this.
All right. Mr. Thomas, did you understand all the rights that the DA just reviewed with you?
Yes, Your Honor.
Have you had a sufficient amount of time to discuss this case with your attorney, Ms. Cabrera?
Yes, Your Honor.
Are you satisfied with legal counsel that Ms. Cabrera has afforded you?
Yes, Your Honor.
Do you expressly give the court permission to sign your name to this bill of indictment? You can see right there, I signed your name, and down here below it, I said by H.M. Newkirk, that's me, for a Zoom hearing.
Yes, Your Honor.
Okay, is that all right with you?
Yes, Your Honor.
And have you discussed your waiver of your physical presence here in the courtroom with your attorney and agreed to go forward with this Zoom hearing in lieu of a personal appearance down here in court?
Yes, Your Honor.
How old are you, Mr. Thomas?
I'm currently 25 years old, sir.
35?
25.
25. And do you live with your mother?
No, ma'am. No, sir.
Where do you live?
I live with my grandmother.
All right. And did this incident take place at your mother's house or your grandmother's house?
That was my grandmother's place, but my mother stayed on Gobby Road.
All right. What type of work have you done?
I was working at a restaurant called Barbaritos,
Right.
Cantina. And I also done roofing work also.
Do you understand how dangerous it is when you pick up a knife and threaten somebody with a knife?
Yes, sir.
I mean, that's pretty serious. Yeah, the law provides 1 to 20 years. So if you need some anger management counseling, I hope you get it. But when you get upset, you got to be able to do something besides retaliate with anger and physical violence. You got to leave. You got to leave the situation, walk around the block and say, boy, I'm glad I left the house so I'm not going to jail today. Because you're picking up a number of cases for a young man, and eventually it's going to haunt you if you don't change your ways.
That was one of the main reasons why I had left the scene at that moment too, though, because everything was just out of hand at the moment.
Yeah, but you need to leave before things get out of hand. Mr. Cabrera, what would you like to add?
Yes, so he mentions that things get out of hand. They do. His mother gets arrested and charged that same day. She has an open case. It's not indicted yet. But she's on bond for battery against him and then the girlfriend who was pregnant at the time. And so another one of these completely unhealthy situations. The young man does have 3 small children. He does have a matter out of DeKalb County that he needs to respond to, and anything that unfortunately may happen with any open probation. So I think the state had asked for 5 to serve 1. I didn't hear in the beginning if she said commuted to time served or credit for time served, but my guess is that she probably said credit for time served. The only variance would be, and I would ask that it be commuted to time served, since I'm not really sure what they're going to do with him in DeKalb. Not to mention he has a bond on this case and they couldn't get him to DeKalb even with the bond. So he may be sitting for a while.
All right. Mr. Thomas, I'm going to sentence you to 5 years, serve 1 year. I'm going to commute the 1 year to time served, balance to be served on probation. You're not to have any further violent contact with anyone, particularly a family member, and must comply with all the rules and regulations of probation. If the cocaine deal is something that is a problem for you, you need to get treatment. I don't know if it's a problem for you or not. It obviously was a problem for you to lose the money that you spent on the cocaine because you got mad enough to threaten your mother. So there's a problem there with your anger, and it's stemmed from the drug use. Your mother's trying to save your life and put you in a different direction, obviously, that's going to be for the better for you. And at 25, you ought to realize that. So that's the order of the court. You can stand by your plea or you can withdraw your plea. If you stand by your plea, you have 30 days to file a notice of appeal, and you have until the end of this term of court to file a motion to withdraw your plea. The end of this term of court is in January, March, April, May, June, the end of June. Do you understand that?
Yes, sir.
Would you like to stand by your plea and accept the court sentence?
Yes, sir.
All right. Good luck to you.
All right. Thank you.
Yep.
Thank you, Judge.
Thank you.
That was my last one. May I be excused?
You may. Thank you very much. Glad to see
Thank you, Judge. Have a good one.
You too.
Can I ask the deputies, do we have Darius Brown ready and available?
I'll be over there a little bit. I'm on full south. Now I got Mr. Bennett ready.
Okay.
Mr. Bennett.
Okay, position.
We can do Mr. Brown next.
Okay, yeah, if we could do Mr. Brown next, that would be great. I have an attorney that has to get to Bartow County for an in-person hearing. So that would be great if you could do that. Thank you so much.
Okay. This is number 8, Mr. Bennett.
This is 7 and 8.
7 and 8.
Okay. Good morning, Mr. Bennett. Are you ready?
Yes, ma'am.
And Judge, excuse me, Ms. Chenault, I'm sorry.
Yes, Max.
Judge, good morning.
Morning.
I represent Mr. Bennett and I gave him a general understanding of what was going to occur. However, the jail phones didn't pick up yesterday when I tried to solidify the specifics with him, per the instructions on the email. So I just wanted to perhaps just be able to tell him exactly what was happening.
All right, would you like to speak to him right now?
Yes, and I don't even think I need a private room.
Okay, go ahead.
Mr. Bennett, good morning.
Good morning.
I know that we discussed working out a plea on this case and getting you home as soon as possible. The state did say that they were willing to let you plead to both your charges, and they're recommending 6 months to serve. 5 of them you've already served. Okay. And I think you probably talked to your mom about this, correct?
Yes, sir.
Okay. Does this sound like what we discussed and you want to go forward?
Yes, sir.
Okay. I tried to call you yesterday to do this, but I just want to make sure before we even started the process. Okay.
Yes, sir.
All right. Good deal. Thanks.
All right. Go ahead, Ms. Chenault.
Thank you, Judge. This is Mr. Bennett. He's here for 2 cases. He's here for 19 SC 173691 and indictment number 20 SC 174476. Mr. Bennett, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Before we begin, Mr. Shart, have you discussed today's proceedings with your client, Mr. Bennett? Mr. Shart?
Max?
I'm sorry. We have discussed what is to occur today.
Oh, and does your client fully understand that he will be appearing via Zoom and not be present in the courtroom?
He does.
Did you obtain a waiver, whether verbal or written?
I'm gonna fail.
We discussed it and I obtained a verbal waiver.
Okay. Mr. Bennett, have you discussed today's proceedings with your attorney?
Ma'am?
Did you discuss today's proceedings with your attorney?
Yes, ma'am.
Did your attorney explain to you that you have the right to be physically present in the courtroom?
Yes, ma'am.
And did you waive your right to be physically present?
Yes, ma'am.
Do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, ma'am.
Defense counsel, do you also waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
So waived.
Your Honor, the state also waives an original signature on the indictment and authorizes the court to sign on its behalf.
All right, thank you.
Thank you. Now, Mr. Bennett, please state your true, correct, and legal name.
James Horace Bennett Jr.
You said James Horace Bennett Jr.?
Yes, ma'am.
Please spell.
I'm sorry, Ms. Chenault. Mr. Thomas, if you can speak up through your mask, that would be great.
All right, go ahead.
Mr. Bennett, please spell your middle name.
Horace.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
45.
How far have you gone to school?
11.
Did you obtain a GED?
Yes, ma'am.
Are you able to read, write, and understand English?
Yes, ma'am.
Do you understand that you're pleading guilty to 2 different indictments?
Yes, ma'am.
Okay, in indictment number 19, SC 173691, you're being charged with entering auto. And in indictment number 20, SC 174476, You're being charged with theft by receiving stolen property and driving without a valid license. You understand those charges?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these indictments?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Shard, about all the facts and circumstances known to you regarding charges in this indictment?
Yes, ma'am.
Did you all also discuss potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney? I'll ask you again. Do you need more time to discuss either case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of both indictments?
So wait.
Counsel, do you waive any and all defects in both indictments?
Yes.
Mr. Bennett, were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any?
No, ma'am.
I don't.
Has your attorney advised you as to the minimum and maximum sentence for each charge you're pleading to?
Yes, ma'am.
In indictment number 19 SC 173691, count 1, entering auto is punishable from 1 to 5 years in prison. Count 2, theft by taking, is a misdemeanor, punishable up to 12 months in prison. And in indictment number 20 SC 174476, theft by receiving stolen property, count 1 is punishable from 1 to 5 years in prison. And count 2, driving without a valid license, is a misdemeanor, punishable up to 12 months in jail. Do you understand these sentences?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
Well, actually, it's non-negotiated. The state and the defense, we agree on the time to serve, but your attorney wants to ask for community time served, and the state wants to ask for credit to time served. So the state offer is 2 years to serve 6 months, credit for time served, with the balance on probation. Do you understand this offer?
Yes, ma'am.
And did you discuss this offer with your attorney?
Yes, ma'am.
Are you aware that the court can sentence you to any sentence authorized by law?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on future convictions if you have,
Yes, ma'am.
and that goes to district as well as outside jurisdictions? Do you understand?
I'm sorry. That goes for this jurisdiction.
As well as outside jurisdictions.
Thank you.
Ma'am.
Do you understand that this plea can enhance sentencing on future convictions, whether they be convictions in Fulton County or outside of Fulton County?
Yes, ma'am.
So wherever you go, if you commit another offense and get sentenced, this plea will come up. You understand that?
Yes, ma'am.
And this plea may enhance sentencing on future violations of the law. You understand that?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to having the balance revoked?
Yes, ma'am.
Do you understand that you're not allowed to use or possess a firearm while you're on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve in a jury, the right to obtain a passport, the right to receive, possess, transport a firearm, or the ability to obtain employment. Do you understand these rights?
Yes, ma'am.
And you understand that they may be impacted by you pleading guilty today?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including with respect to your mental health, by entering a plea of guilty?
Yes, ma'am.
Do you understand that you're giving up certain rights you would have had at a trial?
Yes, ma'am.
Those rights include the right to a trial by jury, the right to remain silent, the right to confront witnesses, the right to the assistance of counsel, the right to presumption of innocence, the right to testify, the right to subpoena witnesses, the right to have the charges proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand these rights?
Yes, ma'am.
And you understand that you've given them up by pleading guilty today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am. How
do you plead to the charges of entering auto and theft by taking in indictment number 19 SC 173691?
Guilty.
And how do you plead to the charges of theft by receiving stolen property and driving without a valid license in indictment number 20 SC 174476?
Guilty.
Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal these guilty plea convictions?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging whether these pleas were voluntary?
Yes, ma'am.
Thank you. As to Mr. Bennett's criminal history, the state notes that Mr. Bennett has 5 convictions. They are all old convictions. He has a burglary out of Fulton in 2001, a theft by receiving stolen property out of Fulton in 2002, entering auto out of Fulton in 2004, another entering auto out of Fulton in 2004, and a third entering auto out of Fulton in 2006. As to indictment number 19 SC 173691, had this case gone to trial, the state would have shown that on November 18th of 2019, officers were dispatched to 3601 Southside Industrial Parkway in reference to a theft from a vehicle. After arriving at the residence, the officer was approached by a female, the victim in this case, Miss Gladys Jackson Rubel. Her first name is Gladys. Her last name is hyphenated, Jackson, Jackson hyphen Rubel, Rubil. Miss Jackson Rubel stated that when she left work, she was walking to her vehicle. When she arrived at her vehicle, she noticed that the driver's side door was open and that a male was standing in front of the hood of her vehicle. When the male noticed her, he grabbed the battery from her vehicle and ran to another side of a building. The victim was able to give a description of the male. She stated that he was approximately 6'4" with a slender build. She also stated that he was wearing a black and tan striped jacket with jeans, and she noted the direction in which he fled. The officer advised the manager of a local store about what had happened, and he asked to see the surveillance cameras. The officer was also able to retrieved prints from the driver's side door, the passenger side door of the vehicle, and the prints returned to Mr. Bennett.
And where was the battery located?
Inside the car.
Inside the passenger compartment?
The battery,
Did he take?
I believe he took the car battery.
Okay.
That's my understanding, Judge.
All right.
And as to indictment number 20 SC 174476, as alleged, the defendant was caught driving a stolen vehicle by an officer in a search incident to arrest, and this was in Fulton County, Georgia. In a search incident to arrest, the officer found tools on the defendant that suggested that he may have stolen the car. Nothing further from the state at this time.
All right. Mr. Bennett, did you understand all the rights that the DA just reviewed with you?
Yes, Your Honor.
And did you say you're 35?
45.
45 years old. And you understand that by entering this plea today, you're giving up the opportunity to be here in person in front of me. And also you're giving up your right to trial by jury, to your right to cross-examination of state's witnesses, your right to testify in your own defense if you chose to. Do you understand that?
Yes, sir.
Has anyone made any promises to you or threatened you in any way to induce you to enter these two pleas today?
No, sir.
Did you give your attorney and do you give me express authority to sign your name on the bill of indictments entering your guilty plea?
Yes, sir.
All right, I'm going to hold up the indictments. I've signed your name. I don't know if you can see it or not, but I've signed your name and counsel's name, and then I signed my name down below indicating that this hearing was conducted on a Zoom teleconference. Is that all right with you?
Yes, sir.
Okay. Defense counsel, Max?
Yes.
Go ahead.
Oh, I'm sorry, Judge. Mr. Bennett is 45 years of age. Obviously, he does have a criminal history, but it appears that that criminal history is from over a decade and a half ago. I spoke to his mother extensively about this case and kind of what happened with Mr. Bennett because he was living with her. She's worried to death about him, especially with the health, scares going on in our society right now. But she was also disappointed that he found himself in this position again. She thought that he had kind of turned the corner over the last 15 years. I think this was a wake-up call from Mr. Bennett. I have discussed the situation with Mr. Bennett as well as his mother and the state about the source of this. And I think that myself and the state are in agreement that if Your Honor would grant him probation, a substance abuse evaluation, and any treatment that's warranted be part of the order. And other than that, Judge, the state is asking for 6 months. Mr. Bennett has served 5. He's wanted to accept responsibility from the beginning in this case. And right now, my understanding, unless something has changed, he is healthy. And I would just ask that you would consider commuting the 6 months to the 5 he's already served, so he can return home.
Mr. Bennett, you went for a long time without being involved with the criminal justice system. What kind of things were you doing over that 10-year period?
Basically the same thing, but I just wasn't getting caught.
You're committing crimes, just not getting caught?
Yes, sir.
Well, that's not good. You got to figure out
Your
something
Honor.
else to do. Yes, ma'am.
Your Honor, Mr. Bennett just got off probation off of Clayton for an armed robbery, aggravated assault, 2 counts of false imprisonment.
I lost you.
Hold on, Judge.
Okay.
There she goes.
Sorry, no with that. But he just out probation September 3rd of 2019 off that Clayton County case.
Miss Pretty, we couldn't hear anything you said.
Okay, I'm sorry. I don't know what happened. He was on probation out of Clayton County. The docket number is 2010CR 62308, and those charges was armed robbery, aggravated assault, false imprisonment.
It's not working. It's not working, Miss Pretty. Miss Pretty, it's not working.
Still not. Okay. Can
You're
you
all
hear me
chopped up.
now? I don't know what's going on with my he just got off the Clayton County probation case. The case expired September the 3rd of 2019. Armed robbery, 2 counts of false imprisonment, forgery in the 2nd degree.
Hold on. Hold on. Three counts of armed robbery.
She's gone. Give us just a second, Melanie. It could be the cloudy weather, guys.
Okay, let me ask this. Mr.
No, I'm
Bennett,
sorry. Yeah, that was he's been on probation since 2010
So he got
at Clayton County, and it just expired in September 19.
So the armed robbery was reduced to robbery.
Yes. Can you hear me? Hello?
Yes, I can hear you now.
Okay.
Okay, let me hear from counsel again.
Judge, I think that this conviction that Ms. Pretty's speaking of, obviously Ms. Chenault and myself were unaware of it. But it sounds like he was given probation in 2010 and until recently successfully, well, I guess Mr. Bennett gets an A for honesty, saying that he was not necessarily a model citizen, but as far as any records or court records regarding being charged with any offenses or running afoul of probation, it seems that he completed the probation approximately a decade later. But we were unaware of that case, at least myself.
Okay, well, it's on one of the in Bill of Indictment 476. It's in the file. It is being filed with the DA's office. Mr. Bennett, you really need to get a different line of work that involves picking up a paycheck and going home. And of course, these times are tough. But I'm going to sentence you on Bill of Indictment ending 691 to 3 years served 6 months. I'm going to commute the 6 months to time served, balance probated. I believe that count 2 is going to merge into count 1. He's charged with entering with intent to commit a theft and with the theft, and yeah, I think he can have one or the other. But that's what I'm going to do, and I'll null cross count 2 as to Bill of Indictment ending 476. I'll sentence you to 3 years, serve 6 months. I'll commute 6 months time served. The balance will be placed on probation. As to count 2, I'll sentence you to 6 months to serve, and I'll commute that to time served.
Judge, you said as to 691, you said that you're gonna null pros count 2 or just merge count 2?
Well, I'll merge count 2.
Okay, thank you.
Mr. Bennett, so your total sentence on each case is 3 years, serve 6 months. I'm going to commute the 6 months to time served. The balance will be probated, and I don't expect to see you come back before me again.
Yes, sir.
And I hope it's not just because you're not getting caught. I hope it's because you're not breaking the law and you're doing something honest.
Yes, sir.
Good luck to you.
Thank you, sir.
And Mr. Bennett, I tell you something, if we weren't in this COVID mess that we're in, you wouldn't be getting this sentence. So don't come back to see me again.
Yes, sir.
All right. Mr. Bennett?
Yes, sir.
You do have 30 days to file an appeal if you'd like to appeal this, this order. And you have until the end of June to file a motion to withdraw your plea if you wish to do so. Do you understand that?
Yes, sir.
All right. Good luck to you.
Is the next defendant Darius Brown?
It's Darius Brown, positions 1 and 2.
Thank you so much. Mr. Melnick? Who's going to be handling this case for the state?
Sorry. Yes, here I am.
Who's handling this case for the state?
Let me check.
It looks like either a Gabriel been something or Lauren McCauley, but I don't see either of them on.
I'm sorry, they just got my case. Let me call you or call me back this afternoon, okay?
Let me text them real quick. And this is for which
positions 1 and 2?
Okay, let me text them real quick. 1 second.
Hold on, Jonathan.
Sure.
Did Lauren respond to you, Jonathan?
No, I was just checking my phone. She has not responded to me.
Okay. And I don't know this other ADA.
I can, if y'all want to take, I mean, I can see Mr. Brown is on the video screen. So, but if there's nobody from the DA's office to handle the case, y'all can take up something else. And I can just keep it, you know, keep the hearing going until about 12 or so, but I do have to take off at 12, and I would stay longer in all honesty, but my hearing in Bartow County was moved from tomorrow to today. It was supposed to be tomorrow morning at 9, and they moved it to today at 1 o'clock, and that's in person, so I've got to be there. If for some reason we can't do this, Ms. Simpson, you probably have more knowledge about this than anybody else. Do you know how quickly they can put him back on the calendar? I mean, I know that
I don't
really
generate
takes an act of God to do this at this point.
Right.
So
I don't generate the calendar. So I wouldn't be able to tell you that, but I can get an answer for you.
okay. All right.
Yeah, I'm not totally sure.
Well, if y'all want to take up something else, I don't want to, I mean, I know we've got a lot of people on this hearing and I don't want to take up a lot of people's time.
Give me just a sec. Give us just a second. Let's see if we get a response. I only have one other defendant with Max, and well, actually 2 other defendants, and we'll be done.
Okay.
But any prosecutor should be able to handle the case.
Right.
If they got some literature.
The only defendants I see remaining are Murray and Brown.
Judge, we have an add-on calendar with the Cedric Hart.
Okay.
I sent that calendar to you as well. Ms. Chenault, any response from anybody? I would like to get all of these done. Is this a get out of jail plea, Jonathan?
He'd have to serve a little more time. He'd have to serve about another month or so.
Oh, well.
Yeah, no, I head up.
Which DA have you been dealing with, Jonathan?
Lauren McCauley.
All right.
Okay, so let me call her.
I just sent her a text a second ago.
Give me just a second.
I'm gonna go off the record. Is that okay until we get this figured out?
Yes.
Okay. So Lauren just sent me an email. She says, based on our conversation, the agreement is 5 to serve 9 months. Is that the agreement?
That's correct. Yes.
Okay. So if you guys give me a minute, I can look up the facts. I'm not sure what's going on with Gabby, but I can look it up and do it. Let me see.
Thank you, Ms. Chenault.
Sure. 175. Okay. Okay, I'm ready. Mr. Brown,
Yes, ma'am.
please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
Thank you. You may lower your.
Ma'am.
I said you may lower your hand. Thank you. Okay, Mr. Melnick, before we begin, I'm going to ask you a few questions.
Sure.
Mr. Melnick, have you discussed today's proceedings with your client, Mr. Brown?
I have.
Does your client fully understand that he will be appearing via Zoom and not present in the courtroom?
He does.
Did you obtain a waiver from your client?
Verbal.
Verbal, okay.
Mhm.
And Mr. Melnick, do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
I do on behalf of my client and on my behalf as well.
Thank you. And Mr. Brown, have you discussed today's proceedings with your attorney?
Yes, ma'am.
Has your attorney explained to you that you have the right to be physically present in the courtroom?
Yeah, ma'am.
Do you waive your right to be physically present?
Yeah.
And do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
Yes, ma'am.
Judge, the state also waives an original signature on the indictment and authorizes the court to sign on its behalf.
And that's as to both indictments?
Yes.
All right.
Okay, there are two indictments.
Right,
Okay,
right.
so bear with.
Yes.
Okay. So, Mr. Brown, you are pleading to indictment number 19 SC 73937 and indictment number 20 SC 175330.
Yeah, ma'am.
Please state your true, correct, and legal name.
I didn't hear you, ma'am.
Please state your true, correct, and legal name.
Darius DeMonte Brown.
Thank you. Can you spell your middle name, please?
Ma'am.
Can you spell your middle name, please?
DEMONTA.
How old are you?
29.
And how far have you gone in school?
11th grade.
Did you get a GED?
No, ma'am.
Are you able to read, write, and understand English?
Yes, ma'am.
Do you understand that you're being charged with the following offenses? And I'll read them. In indictment number 19 SC 173937, you're being charged with possession of marijuana with intent to distribute, possession of a firearm or a knife during commission of a felony, possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, and loitering. You
Yes,
understand?
ma'am.
And in indictment number 20 SC 175330, you're being charged with possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, possession and use of drug-related objects, and willful obstruction of a law enforcement officer misdemeanor. You understand those charges?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Melnick, about all the facts and circumstances known to you regarding the charges in both indictments?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive formal reading of both indictments?
We do.
Do you waive any and all defects in the indictments, including with respect to your name?
We do.
Mr. Brown, were you on these
I didn't hear
charges?
you. I didn't hear you, ma'am.
Okay, I was asking if you would waive any defects in the indictment and your attorney on your behalf.
Yeah, ma'am.
Mr. Brown, were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of it?
I'm not aware of any.
Has your attorney advised you as to the minimum and maximum sentence for each charge you're pleading to?
Yes, ma'am.
In indictment number 19 SC 173937, count 1, possession of marijuana with intent to distribute is punishable from 1 to 10 years in prison. Count 2, possession of a firearm or a knife during commission of a felony is punishable from 1 to 5 years in prison. Count 3, possession of cocaine with intent to distribute is punishable from 5 to 30 years in prison.
Yes, ma'am.
Count 4, just to be clear, was the defendant, Mr. Brown, charged with possession of marijuana with intent to distribute twice?
I did not hear that. The last thing you said, Ms. Chenault.
Oh, thank you. I'm asking a question because I don't have the indictment. Was Mr. Brown charged with possession of marijuana with intent to distribute twice?
I think in 2 separate indictments. Is that what you're asking me, or do you mean
No,
twice?
in bill of indictment ending 937, there's 2 counts of possession of marijuana with intent to distribute.
No, I think those are just alternative counts.
I
In other
can,
words, one of them would merge into the other.
All right.
Okay, I'm just making sure. Okay, and then loitering is a misdemeanor punishable up to 12 months in jail. You understand those sentences?
Yes, ma'am.
Okay, and in indictment number 20 SC 175330, count 1, possession of cocaine with intent to distribute is punishable from 5 to 30 years in prison. Count 2, possession of marijuana with intent to distribute is punishable from 1 to 10 years in prison. Count 3, possession and use of drug-related objects is a misdemeanor punishable up to 12 months in prison. 12 months in jail. And willful obstruction of a law enforcement officer is also a misdemeanor punishable from 1 to 12 months in jail. You understand these sentences?
Yes, ma'am.
Okay. And ADA Beignet has arrived. Madam Court Reporter, would it be okay for her to take over, or do I need to continue with the plea?
No, that's fine. I just need to know a spelling of whoever's coming on.
Yes, Madam Court Reporter. So my name is Gabriella, Gabriela, and the last name is Bengiat, B as in boy, ENGHI. Is it cutting out?
Yeah, you're good.
Okay. So the last name is again, B as in boy, ENGHIAT as in Tom.
Okay, thank you.
No, just pulling up. So, Your Honor, had this case gone to trial, the state would have shown beyond a reasonable doubt that in indictment number 19 SC 173937, that on August 9th, 2019, Atlanta PD officers conducted a suspicious persons stop at the Chevron gas station, which is located at 3260 Donald Lee Hollowell Parkway Northwest in Atlanta, Georgia. That was in response to 2 individuals. Oh, Oh, sorry, did we not finish the plea litany? My apologies. I will pull it up.
Oh, I can let you know where we finished. We finished right after the minimum and maximum sentence for each charge.
Right.
We will be starting at number 17.
I'm just trying to grab it. I thought. Here we go. Got it. So done with the minimum and maximum. Sorry, scrolling down. So Kiana, where did you leave off? I'm sorry. What number?
Number 17.
Number 17. Thank you.
Or either can Kiana just go ahead and finish the plea?
No, counsel can go ahead go forward.
Okay.
Thank you, Your Honor. All right, Mr. Brown, do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 9 months, balance probated, special conditions of that probation that he stay away from each incident location. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively, which means one after the other.
Yes, ma'am.
Do you understand that you are? Scroll down. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of anything your attorney or anyone else might have told you?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or the court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Okay, how do you plead to the charges of? Let me pull it up. How do you plead to the charges in indictment number?
You said how do?
No, it's 19 SE 173937. In that case, how do you plead to the charges of 1 count of possession of marijuana with intent to distribute, 1 count of possession of firearm or knife during commission of a felony, 1 count of possession of cocaine with intent to distribute, and 1 count of loitering or prowling? How do you plead in that case?
Guilty, man.
Okay, and in indictment number 20 SC 175330, how do you plead to the charges of 1 count of possession of cocaine with intent to distribute, 1 count of possession of marijuana with intent to distribute, 1 misdemeanor count of possession and use of drug-related objects, and 1 misdemeanor count of willful obstruction of law enforcement officer?
Guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Sir?
I didn't hear you, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay, Your Honor, had this case gone to trial, the state would have shown beyond a reasonable doubt that in indictment number 19 SC 173937, that on August 9, 2019, APD officers conducted a suspicious person stop at the Chevron gas station located at 3260 Donald Lee Hollowell Parkway Northwest within Atlanta, Georgia, within Fulton County, on 2 individuals that had been loitering on said property. In the past, APD's crime suppression team had made several narcotics related cases at that location, and it was a known hotspot for the sale and distribution of narcotics. The Texaco across the street had been shut down, apparently due to being overtaken by narcotic sales and drug dealers. So the owners of that Chevron gas station had requested a strong police presence to prevent the same thing from happening to them. So the APD officers first observed Mr. Brown's co-defendant, Brianna Michelle Smith, and then the defendant, Mr. Brown, around 7 p.m. They were loitering on the property in the parking lot for almost 20 minutes. When they saw law enforcement, they tensed up, and the defendant, Mr. Brown, began to kind of walk away, which, due to the officer's knowledge and training, caused them to have a little bit of concern. It was very hot outside that day, so it was kind of uncommon for them to be hanging around outside of gas stations. Anyway, the co-defendant, Smith, had already been arrested for several narcotics and illegal firearm possessions at this location in the past, less than 2 weeks prior. And Mr. Brown also had a warrant for traffic charges out of APD. So they called K9 out to the scene, and Officer Munson of APD and his K9 jet recovered a bag near the dumpster on the western side of the building, and inside of that bag was 20.7 grams of marijuana in 17 individually packaged baggies and 3 grams of crack cocaine. Law enforcement then reviewed the business's surveillance cameras, and the defendant, Mr. Brown, was observed going back and forth to that bag by the dumpster and conducting hand-to-hand transactions with other individuals in the parking lot. So due to the amount of packaged marijuana, the fact that there was $103.40 in smaller denominations.
Sorry, $103 and what?
40 cents found in smaller denominations, and the surveillance camera footage, officers arrested Mr. Brown and charged him with possession of marijuana with intent to distribute, and possession of cocaine with intent to distribute, and the loiter or prowl in that case, I believe.
Tell me about the gun.
So,
I believe you just gave a statement of facts on indictment 937.
Yeah, it says it on there. My apologies. The calendar is incorrect. In indictment number 19 SC 173937, it shows he was only charged with the possession of cocaine with intent to distribute possession of marijuana with intent to distribute, and then the misdemeanor loitering and prowling.
Okay,
So Mr.
you'll,
Melnick was correct on that other count.
so you'll null pros count 2 on that indictment?
I would assume, I don't even know if it needs to be null pros because I'm not showing it on our indictment.
Oh, okay.
I
don't have that indictment directly in front of me, so.
I will pull it up, Your Honor. I'm going to pull it up right now through the case manager system.
I failed to note that it was back in chambers and I haven't gone back to get it.
The thing with this case is it was a re-indictment of another case. So, okay, no, it is here on the official indictment, but yeah, it's a little, I believe Mr. Melnick and Ms. McCauley, my supervisor, had agreed to this plea prior to. This was originally my case, but they had come to this agreement. He's supposed to plead on all counts, and I do see on the indictment, both he and the co-defendant have that possession of firearm during commission of a felony. Well, there's not a lot in terms of the report explaining. It does say in the indictment that there was a firearm within reach or on the defendant, and he was charged with the crime of possession of marijuana with intent to distribute. So it is.
I'm looking at the discovery right now to see where that comes in. And I'm sorry, we're talking about the first case here?
Yes.
Yeah, the case ending 937.
I remember seeing it. Just bear with me, y'all. I'm sorry.
Yeah.
I'd called up the other one here and I got to go back. This, I guess, is the problem with all this late.
Okay.
No, that's the same one. Gabriella, I'm sorry, I actually don't see it on here. I don't see a factual basis for that, so I can't really advise them.
Well, the problem I have with that is, you know, you came to an agreement with the state through Ms. McCauley and agreed to plead to this charge. I'm showing
a factual basis for the charge.
Well, I'm showing in our summary when the officer went and testified in grand jury, while it's not in the report, that in the vehicle, when they made contact with Brianna Smith, in the front passenger vehicle that Mr. Brown had fled from, they found loose marijuana as well on the ground between the gas pump and the driver's side of the vehicle, the same path that Brown had fled from. Also in plain sight inside the vehicle was a rolled blunt of marijuana and 1 round of .40 caliber ammunition of a firearm laying in the middle console of the vehicle, loose marijuana on the driver's side floor mat along with a $20 bill in U.S. currency, and a black digital scale and a black Sig Sauer P225 .40 caliber pistol on the rear driver's side floor.
Can you say the kind of gun again, please?
A Sig Sauer.
It was a Sig Sauer P225 .40 caliber.
I can accept that.
Okay. All right. That solves my question.
Yes.
Anything else?
Yes, so he was arrested and charged in that case on the 20 SC 175330 on January 2nd, 2020 at approximately 5:45 p.m. Officer D. Diaz Taylor and the rest of Zone 1's crime suppression unit with Atlanta PD were conducting surveillance. So the original address of 19 SC 173937 was the Chevron on 3260 Donald Lee Hollowell. In this case, they were conducting surveillance at the Valero gas station at 3170 Donald Lee Hollowell Parkway, Northwest Atlanta, Georgia, within Fulton County, so very short distance away. This location was also, as the other location, known for sale and distribution of narcotics. They have a long history regarding 911 calls being made for people loitering and selling drugs. So the officers had been granted permission by the owner of that Valero gas station in writing, authorizing any city of Atlanta police officer to arrest any persons on his property making sales of narcotics. It's important to note that as I go into the summary, that all 4 male arrestees in this case had previously been issued verbal criminal trespass warnings at this location. So while conducting surveillance, the officers observed a dark-skinned male with a gray beard, white hat, black Nike hoodie, and black Nike pants, who was going to be identified as Mr. Vice Bradford, who was a co-defendant, lingering in the general area near the intersection, conducting multiple hand-to-hand transactions. It appeared he would take money from multiple people, then send them up the trail to meet with another black male in a black jumpsuit wearing a black skull cap, who was later identified as the defendant, Mr. Brown. Mr. Brown appeared to be the lookout and had a direct hand in assisting with the sale of the narcotics. Officers observed the 2 males there for hours, conducting multiple transactions and working in concert with each other. The units then observed a vehicle pull up and Mr. Bice make another hand-to-hand transaction. I guess it was at that point they decided to move in. And when the defendant saw the law enforcement officers, he did flee the location. He sprinted down Harwell Road, heading southbound. He then jumped into the wood line there and discarded narcotics into the bushes to try and avoid being caught by police. He was apprehended a short distance away from where the narcotics were abandoned. And as law enforcement walked the path he had run, they recovered a purple Crown Royal bag containing 35 grams of marijuana, individually packaged for sale in 13 baggies, 3 grams of crack cocaine that was also individually packaged into 3 baggies, a black digital scale, and $194 in US currency in small denominations. After he was arrested and transported to the Zone 1 main precinct, the defendant, Mr. Brown, was read his Miranda rights, and he did waive them and affirm that he did abandon that bag containing the narcotics during the foot chase. He was charged accordingly at that point. And that's the case we have for the 20 SC 175330. Sorry, in regards to criminal history, I'm showing the defendant as 15 prior arrests, but out of those, it looks like he has no felony convictions. It looks like it's just these 2 open felony cases that we're resolving together today, with the 5 years to serve, 9 months, balance probated, and again, issue a stay away order from both of those gas stations.
All right, Mr. Brown?
Yes, sir.
Did you understand all the rights that the DA's recited to you that you're giving up or waiving by entering this plea today?
Yes, sir.
Do you have any questions about any of the rights that you're giving up or waiving? And if you could scoot back just a little bit, I can't see your full face.
I can't hear.
Okay. Can you hear me now?
Yeah, I can hear you.
Okay. I'm holding up the original bill of indictment, and I don't expect that you'll be able to read it all, but right over here in this area, I signed your name up there on the top.
Yes, sir.
Do I have your express permission to sign your name on this original bill of indictment?
Yes, sir.
For the purposes of this hearing and purposes of resolving this case. And
Yes,
I
sir.
also signed the name of Mr. Melnick. Mr. Melnick, is that all right with you?
Yes, Your Honor.
And I signed the name of Ms. Chenault as well, and I signed my name beside it. Do you have any, do you understand that you're giving up your right to trial by jury by entering this plea, and you're giving up your presumption of innocence and your right to testify at your trial?
Yes, sir.
And you're also giving up your right to present defense witnesses to testify on your behalf.
Yes, sir.
How old are you?
Sir?
How old are you?
I'm 29, sir.
And you went through 11th grade. What type of work have you done?
Well, I was working at the temp service. Like they had me working at DHL warehouse, but I done lost that job. But I have a job like waiting on me now. It's a hotel job. My mama friend said she'll give me a job at a hotel. But before I came in here, I was working at the DHL warehouse.
Well, I guarantee you one thing, it's gonna be harder to get a job now than it was when you got arrested. So I encourage you to try real hard to get a job, maybe in the service industry that hopefully is coming back, or DHL. But your current course of breaking the law is not going to work out well for you in the long run. You picked up a number of arrests and somehow have avoided conviction, but these cases are very serious cases, and you need to pick up another line of work. Because
Yes,
if you get popped on your case is going to go back to Judge Ellerby, who is the judge assigned to this case.
Yes, sir.
And I think all of us on this call know what Judge Ellerby will do with you. She's going to lock you up for the balance of your sentence.
I won't never get in trouble again. So I'm not going back to that lifestyle.
Well, I hope you don't. We all hope you don't, but the only person that control that is you.
Yes, sir.
On bill of indictment ending 937. Well, hold on a second. Ms. Melnick, anything else you'd like to add?
Judge, I believe that he is eligible for treatment under the First Offender Act. I would ask that he be allowed to plead under the First Offender Act.
I don't think he'd be eligible on both cases.
I'd ask that he get it on the first one, Your Honor.
And that's the, yes. Did somebody say judge? That's the bill of indictment ending 330.
Yes.
Judge Melanie is frozen. Give us just a second. Mel, we hear you. And Judge, just while we're waiting on Melanie, are you going to put both prosecutors on it?
Marion?
Yes, Melanie. We hear you now.
Okay, well, do I need to be on the phone or do you hear me?
We hear you now.
I can hear you.
I was trying to signal to y'all. I lost you, Judge. I never heard anything after the defendant saying I would never get in trouble again, sir. I'm not going back into that lifestyle. I lost the rest.
Okay, and I also had an opportunity for Mr. Melnick to state something.
We're asking he receive first offender treatment on his on that first indictment, Your Honor, the 19 case.
All right. Is there anything that the first prosecutor would like to say?
Hi, Judge. No, nothing further from mediation office.
All right, and I thank you, Ms. Chenault. On indictment 19 SC 173937, I'll sentence you to 5 years served 9 months. On count 2, that sentence must run consecutive to any other sentences I sentence you to. I'll be 5 years. I'll allow that to be probated to run consecutive to count 1 and count 3. On count 3, I'll sentence you to 5 years served 9 months to run concurrent with count 1. And on the next count, the possession of marijuana is apparently merged into count 1. And on the loitering and prowling, I'll sentence you to 6 months commuted time served. As to bill of indictment ending 330, on count 1, I'll sentence you to possession 5 years served 9 months, balance probated. The same sentence for count 2. Count 3 will be 6 months commuted time served, as will count 4, the willful obstruction.
Judge, as to the 5 served 9 months, is the 9 months commuted or is he serving the 9 months?
He's been in for 8 months.
Okay.
I believe that's right, yes.
Yeah, Mr. Brown, I'm going to, because of the situation that our world finds ourselves in, I'm going to commute that extra 30 days to time served. But I got to tell you, you don't want to go back. You don't want to be brought in on a violation because Judge Ellerby is going to slam you.
I got you, sir. I promise I got you.
Okay. Good luck. Take care of yourself and exercise social distancing and go into another line of work.
Yes, sir.
You have 30 days from today's date to file a notice of appeal if you'd like to appeal any issues that occurred today, and you have till the end of the term of court, which is the end of June, to file a motion to withdraw your plea. Do you understand that?
Yes, sir.
Madam Pretty, the probation officer, Ms. Pretty, is going to give you some instructions as to when you need to report to probation.
Yes, sir. You know. Okay,
Yes.
thank you, sir.
Mr. Brown,
Yes, ma'am.
you're gonna report on Wednesday, June the 10th at 10 a.m. to 276 Memorial Drive.
Yes, ma'am.
And I will send a copy to your attorney so he can get it to you as well.
Okay, ma'am. So what day do I be released on?
Probably within the next 24 hours.
Okay, thank you, sir.
Good luck to you.
Okay, thank you.
Stay away from known drug locations.
I promise you I will. I promise you.
All right.
All right, yeah, bro.
Judge, that concludes my business. Can I be excused?
Yes, thank you, Mr. Melnick.
That concludes my business as well. My apologies, Your Honor. I wasn't aware we were moving forward on the plea today, which is why I came in late.
Well, thank you for taking it over and being with us.
Thank you for letting me in. Have a good rest of your day.
You too.
Who's next, please?
Yeah, 5 and 6 kids under quarantine, so we won't be able to come out.
Okay, so number 6, so that's Mr. Murray. We won't be able to do his pleas because he's under quarantine.
Correct.
Okay, so that's 5 and 6. So Max, is that all your business?
That is.
Okay, thank you.
All right, thank you. Thank you, Judge.
Thank you.
The last one is Heart. I think we have. It's an add-on.
Before we start that, Judge, that concludes my business as well. May I be excused?
Yes, you may. Thank you.
Okay, thank you, Judge. Have a good day.
Thank you, Kiana.
You as well.
Thank you, John. Have a good day.
All right. Last one, Cedric Hart.
Give us 1 second to get over there. I didn't see the add-on. My apologies. Give me 1 second to get over there.
That's okay. Thank you.
All right, I'm going to step back in the office for a minute.
Yes, sir. Hey, Miss Patel. Hey, Miss Hall.
How are you?
Hey, y'all.
We finally up. So
excited. Right.
I have been loving your facial expressions in that last one.
I have no
I turned my video off because she was having me laugh over here.
I was dying.
Because I was like, girl, your face, girl, get off the camera. Lord have mercy. But we made it through. We did good.
We did. Took forever, but finally, last one.
Yes. So positions 5 and 6 has COVID-19. I knew he wasn't going to be with us, so.
Terrible.
He has COVID-19?
Yes.
Oh, okay.
Melanie, was that your way of correcting the way that I said corona?
Trying to clarify if that was accurate. Or you were saying
yeah. They told me he wasn't going to be a part of it. I hope he gets better, man.
No,
God,
they're
it's
not gonna
terrible.
see because he's under quarantine. But he caught the mess in there. Jesus, it's crazy.
Yeah, I hope he gets better. I just hate that. I hate this. I hate it. I hate these times.
It's terrible.
Yeah, it's very terrible.
And it's taking forever to move some
Why y'all want to see my son?
Yeah. So so I hate that we won't be able to do his. Oh, everybody's been staying safe.
Oh,
Yes,
yeah.
ma'am.
I've been staying in the house.
Me too. Me too.
Yeah, staying safe, staying out of the way.
Y'all ready to get back to work?
No. They got to make sure that building is sufficient.
Yeah, not until it's safe.
Yeah, not until it's safe.
Look, I'm cool with the June 19th. I mean, June 12th, June 13th?
13th.
I think we'll go back on that Monday. I'm cool with that. I'm cool with another extension as well.
I'm cool with 2021.
I feel like they're not being honest with these numbers and
right.
I'm get sick.
They're not.
So, but it's cool. You know, I have on a dress and I have on shorts under it. Cause you know, we could just.
You doing better than some of us here. I got on a jacket.
Well, you look very presentable.
You do look professional.
This is the same jacket I wear at every Zoom hearing.
I love it.
I need to get a jacket. One day I'm at home, so I had on a sleeveless shirt, and I was like, well, I don't think I need a sleeveless on because this is still court. So wait, and we're still live on YouTube. Let me stop talking.
Are we on YouTube?
Yes,
yeah, we're also live on YouTube. Hopefully nobody's watching.
Yeah. Well, guess what? We were in recess. Court comes.
That's right.
Judge, we on the last one.
All right.
Thank you, Jesus.
And I don't think I have his file.
Okay, it was an add-on calendar. I got the calendar on the 18th of May, actually. I mean, not the 18th of May. I got it on the 13th of May. So.
All right, well, I'll have to get the file subsequently.
Okay.
What's the indictment number?
It's 20 SC 174577. Cedric Hart is his name, CEDRIC. Middle initial is D as in Delta. Hart, HART. Single count of theft by shoplifting.
All right.
Is this a mandatory year theft by shoplifting?
No, it's a reduction.
Okay. What are we reducing it to?
It's orderly conduct.
Oh, cool. Can you give me the code section for that?
Yes, ma'am.
Thank you.
You're welcome. Oh, my red book.
And it'll also be time served, so he will not be on probation.
Okay.
After this.
Miss Pretty, does he have any outstanding probation that you know of?
No, ma'am. All of it is inactive. Last one as of 2018.
Okay.
That's my guy.
And I'm gonna go ahead and apologize for y'all. I know y'all can hear those dogs. Those are my mom's dogs. I inherited them when she passed. They bark when people are outside and the plumber just came. So he's walking around and so they're going crazy right now. So I'm gonna apologize in advance for them.
You should have just told us they're the neighbor's dogs and you're going to call the police.
You know what? I could have done that, right? Code section.
Melanie, are your dogs barking?
No, they're being good.
Yeah.
Melanie dogs are bougie. They're back in their mansion.
These dogs over here are so spoiled. Before we get to the house to pull in, they're barking. And I'm like, really? So they're house dogs, but I had to put them outside for, they needed air from this COVID. They was doing too much in the house. I have the code section for you, Miss.
Okay.
It is OGCA 1611 39 or 39B.
Thank you.
You're welcome.
And that B is in parentheses, right?
Yes, it is.
Got it. All right, and we're just waiting for the guy to show up. And we'll be finished.
Madam Prosecutor, will you please tell me your name again?
Cassie Hall, Kassie, Hall, Hall.
All right, thank you, Ms. Hall.
You're welcome.
And defense counsel?
It's Shalmal Patel. It's spelled SHYAMAL. Last name is PATEL.
All right. And Ms. Patel, are you private counsel or with the Public Defender's Office?
Public Defender's Office, Your Honor.
Okay, very good. And this case is ordinarily assigned to which judge?
Judge McBurney.
Have these hearings been taking place for about 3 or 4 weeks now?
Yes. When was the last hearing we had, Cassie?
With Judge
With
McBurney?
Mr. Bell. Do you remember? That was a month ago, I would say.
Oh, yeah. I don't know. I wrote it down. I feel like it was a month, probably a month and a half ago now. It was when we have probably been home for a couple of weeks when we took that plea.
Okay,
They've been doing it 3 days a week or 2 days a week.
2 days a week, I think.
Yes, sir.
And this is my first time doing it. So
Yes, sir.
I'm glad it's worked so smoothly. Thank you all for your patience and help in this endeavor.
Is this Mr. Hart?
Yes, ma'am. This is Mr. Hart.
Mr. Hart, how are you?
How you doing?
Ms. Hall, you may proceed.
Thank you. Mr. Hart, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. I do have a couple preliminary questions that I need to go over with your counsel and yourself. I'll start with your counsel, Ms. Patel. Have you discussed these proceedings with your client, Mr. Hart?
I have.
Does he fully understand that he will be appearing via Zoom and not be present in the courtroom?
He does.
Did you obtain a waiver from your client?
I obtained a waiver on May 6th through a video Securus conference with Mr. Hart.
Okay. And do you waive your original signature on the indictment and authorize the court to sign on your behalf?
I waive on my behalf as well as Mr. Hart's behalf.
Thank you. Mr. Hart, have you discussed these proceedings with your attorney?
Yes, I have.
Has your attorney explained to you that you have the right to physically be present in the courtroom?
Yes, ma'am.
I'm sorry. Your client waived your right to your original signature on the document. The judge would sign on all of our behalf. And Your Honor, the state waives the original signature of on the indictment and authorize the court to sign on our behalf.
All right.
Mr. Hart, can you please state your true, correct, and legal name?
Cedric D. Hart. Cedric DeCarlo Hart.
Are you able to read, write, and I'm sorry, at this time, are you under the influence of any drugs, alcohol, or medicine?
I'm gonna take psych meds. Psych meds.
Were you given was you given that today?
Yes, ma'am.
Would that affect your ability to understand what's going on here?
No, ma'am.
Okay. Is there any other medications that you should have received that you didn't receive?
I received all my meds, all my medication.
Okay. How old are you and how far have you gone in school?
12th grade, 55 years old.
You said 55?
Yes, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that I'm sorry, for the record, Your Honor, the state is reducing theft by shoplifting to disorderly conduct.
Yes, ma'am.
Mr. Hart, do you understand that you've been charged with theft by shoplifting being amended by the state to disorderly conduct?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to defendant's name?
Waived for the purposes of this plea only.
Okay. Mr. Hart, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to this charge. Do you or your attorney know of any outstanding warrants related to this charge?
We do not.
Mr. Hart, has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
The minimum maximum sentence for disorderly conduct is 12 months to serve. Mr. Hart, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months 12 months to serve 132 days commuted to time served, but the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you are placed on do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other jurisdictions, on other convictions in other jurisdictions, as including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that if you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the single charge of disorderly conduct in indictment number 20-SC-174577?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, had this case proceeded to trial, the state would have proven that on January the 2nd of 2020 at 2539 Piedmont Road, Northeast Atlanta, Georgia in Fulton County, officers were dispatched to that location in reference to a shoplifter at a Target. They spoke with the asset manager protection officer who stated that the defendant came into the store, hid some underwear in his coat, and then attempted to conceal within the coat. The defendant also retrieved an umbrella from the store, also tried to conceal the umbrella as well. The defendant passed all points of sale without paying for the items. The items totaled $99.77. Those items were recovered. This was captured on surveillance at the store at Target. Your Honor, the defendant does have a criminal history. It is kind of old. He does have, looks like 5 prior felony convictions dating back to 1982. The most relevant is a robbery out of DeKalb County. The disposition date was August the 22nd, 2007. The state has decided to reduce these charges because of the time that Mr. Hart has spent in custody at this point, and because of the values. I did speak with Target. They did recover those items. They're not requesting restitution in this case. That is all from the state, Your Honor.
Okay. And how long has he been in jail?
132 days.
Okay.
And Ms. Hall, or I apologize, Your Honor.
Go ahead.
Ms. Hall, the negotiated plea was 12 months to serve commuted time served. You earlier said 12 months to serve 131 days commuted time served, but then that would leave a balance that would have to be suspended. So it could be that or the 12 months to serve commuted time served. Purposes of the record.
Okay. I want to keep the jail time because that's what Ms. McCauley wanted to keep. So we can do it that way, just if we can just keep the jail part.
Okay, so 12 months to serve 131 days.
Balance suspended.
Balance suspended. Okay, thank you.
You're welcome. I'm sorry about that.
No worries.
All right. Mr. Hart, did you understand all the questions that counsel just asked you?
Yes, sir, Your Honor.
You understand that you're giving up your right to trial by jury, and at a jury trial, you'd have a right to cross-examination of state's witnesses. You'd have a right to present defense witnesses. You'd also have a right to testify if you wish to do so. Do you understand that?
Yes, sir, Your Honor.
Have you thoroughly discussed this case with your attorney, Ms. Patel?
Yes, I have, Your Honor.
Do you understand that as a recidivist, your past crimes can catch up to you here pretty fast, and you could be facing some more serious punishment?
Yes, sir, Your Honor.
So I strongly suggest that you pick a different occupation, hopefully one that involves a paycheck and an honest day's wages. So you're not wasting the county's time and wasting your own time too, sitting in jail. I mean, you get picked up for something like this and you risk your life being in that jail just because of this virus. So, I hope you take something away from this and don't come back and see us for a while. Ms. Patel?
Thank you, Your Honor. Just very briefly, my client is 55 years old. He is a high school graduate. He did 2 years.
Judge, I can't hear you.
You can't hear Ms. Patel?
Well, I lost you, Judge. It froze up for a minute, but if you can just, Ms. Patel, if you can just start over.
Sure. My client is 55 years old. He is a high school graduate. He did complete 2 years at Georgia Technical College in the 80s. He, at the time that he picked up this case, was off of his medication. Normally, he's fairly consistent about taking them. He goes to 10 Park Place. He does work, and so when he is released, he will have a safety net. He's got not only his stimulus check waiting for him, but his tax refund as well. Prior to picking up this case, he had been at Staff Zone, which is a staffing agency, but they had placed him full-time as a construction staff worker. And so we are hoping that upon his release, he will be able to get back on his feet. He plans to reside with his fiance while he tries to get a job.
All right.
And nothing further.
Mr. Hart, anything else you'd like to say?
Your Honor, I'd like to apologize to the court and to the staff members for my actions. And I take full accountability for my actions, Your Honor. And make it possible in the near future that I don't make the same error again because I'm getting too old for it.
I'm sorry, I'm having a hard time hearing him now.
He's saying he's very sorry for having brought this trouble upon himself and upon the court. Is that right, Mr. Hart?
Yes, sir, Your Honor.
And you've learned a lesson from this and you're not going to come back to see us anymore, right?
Yes, sir, Your Honor.
All right. Mr. Hart, I'm going to accept your plea to the reduced charge of disorderly conduct. I'm going to sentence you to 12 months, serve 6 months. I'm going to commute the 6 months time served, and I'm going to suspend the balance.
Yes, sir.
So don't come back to see us anymore, all right?
Yes, sir.
Good luck to you. And when you get out, continue to wear that mask and be safe.
Yes, sir. Thank you, Your Honor.
All right. Thank you.
All right.
Deputies, I think that's all we have.
Yes, ma'am. That's it.
Thank you so much for your cooperation. Thank you.
All right, I'd like to thank you all for your help in making this a successful day. I'm going to sign off.
Thank you.
All right. Thank you, Judge.
Thank you.